Thank you. So we are in the middle of the property owner slash operator's presentation, but I did want to clarify after that last speaker. I think that's a question. Okay, okay. The Okay. The last speaker stated that as the property owner of the patio that they did not receive notice of the violations. So I wanted to briefly address that point since that is a very important point. This is the June 16th, 2017 letter that Ms. Coyle testified to. And you can see on here, this is the property owner in question, Isaac Jason Associates, LLC.
You just hold on for a minute, it's not on the screen yet. There you go. There you go. Is that
So 914 North Franklin is the patio, and that is the owner of that. They were sent a copy of the June 16, 2017 letter. I have right here the green card from them. They signed it and received it on June 19th, 2017. And then on November 16th, 2017, this is the second letter that Ms. Coyle testified to. This is the follow-up letter stating they are still in violation. And once again, you will see Isaac Jason Associates, the owner of 914 North Franklin. And again, you have a signature that they received this letter as well. So they were notified of all of the violations. So with that, I believe that it would go back to Ms. O'Donnelly speaking for Franklin Manor. Thank you, Council.
Thank you, Kristen. Good afternoon, Council. I will try to pick back up where we left off. I had to make a clarification that someone kind of elbowed me and told me that I was passed a note about whether there were citations, and I may have said that there were 7 calls, and I think the note said 7 citations, so I probably misspoke. But on the topic of noise violations, I don't believe that's really the subject of what we're here to discuss. It's the 2 issues on the site plan. And when we had talked with the city about this hearing, we were not informed that we were going to sort of try to recollect the history of every phone call and citation that may have occurred. But we have our litigation counsel here if there are questions on that. That's probably a better resource. Going back to, I think we were about to kind of give the update on what the outdoor patio looks like today and where we are in this transition process of moving things forward. And I was going to just hand this out for you as well as put it up on the screen to take a look at the current status. And I'll hand these around for you all to take a look at. So I want to be sure you have these photos that show the condition today. I know Kathy was not able to go over until this morning, and we've already talked through the foam paneling question and our plan to work with her on that. There are not yet individually controlled speakers in these cabana furniture. Those will come in soon, and our plan would be to work with the city and make sure that the city staff comes out and takes a look, and that, again, we're all on the same page as we're trying to move forward. I think this was another item I was trying to get up for you to take a look at. There were speakers that were utilized on the property from the point that they started operating, and you kind of got a look at what they were doing from the time they opened going forward, and so these are now in storage. But there was also, I think, maybe some clarification needed about kind of how we got here, and maybe just a little bit of a quick background and summary about what maybe transpired between the issue in 2017 and that we're here today now at a hearing. And so Eric Koenig is litigation counsel in the pending case with the adjacent property owner, and I think he can provide a real succinct summary for you on that topic.
Ms. Capine.
Yes,
Yes.
when we talked about amplified sound,
I want to know what went with the permit from the beginning. What
So
was allowed?
the note, and I know typically, like if someone was coming forward with a special use permit request today, I think the type of language we would see would be real clear, and I know you've been on top of that specifically, Councilwoman, but it would say something like either no amplified music outside after 10 p.m. or something very, very clear, right? And instead, this 2011 plan says there will also be self-contained individual controls within the cabanas so that the music levels can be sustained at an appropriate level without causing a nuisance to the surrounding areas.
But there's no hours there of
No,
amplification?
there are
Okay.
not.
I just needed to know
So
what
it's
it
kind
was.
of what we're working with is something that's a little unusual and I think left some uncertainty, and that's why when I started communicating with the city several months ago, they needed to come back to me and tell me, you know, yes, this is our position, we're reading this very strictly, or not. We had a different position, and as I was explaining earlier, Franklin Manor believed that they were operating under an approval, that the city had come out and seen the site and had blessed it. And so they were moving forward for a period of time, but you know, nonetheless, we're really here to move things forward and be sure that we're all on the same page and that there's no ambiguity. But that is the text of the note that we're working with.
Thank you.
But if I could, I think that little summary, that little background might be helpful, unless there's something else I can cover.
Thank you. Mr. O'Donnelly, so I want to make sure I'm clear about this, because when we left at the end, we have someone who owns the patio, we have someone who
Yes.
owns the building, we have a renter that rents, I assume, from both entities, is that correct?
Correct.
All right, now, does the site plan include the patio property in addition to it?
Yes.
So what you just read, it includes the entire footprint
Right.
of both owners, correct?
Right.
Okay.
Right, it's the whole, it covers the premises.
All right.
And that was in 2011, of course, predating Franklin Manor. They opened in 2016 and, you know, took a big risk, put together, I think, you know, $2 million to make this happen. And
So let me ask you, so there was no changes to the site plan in relation to the 2016, when they took over the new ownership group from the previous owners?
Correct.
Previous tenants, I'm sorry.
Correct.
Okay.
And then, I know Kathy spoke to this as well, but I think part of what led to this period of uncertainty, whether there was an open issue or not, was that Franklin Manor was saying to themselves, well, this is what we were always doing. It's very clear. You could read the news articles, you know, announcing their business plan, and, you know, people came and walked the site and literally took a tape measure and looked at everything and saw it. And so I think they just, you know, had a firm position on that point. You know, nonetheless, once we've come together with the city, learned that this issue was deemed open, learned that they, though there was some uncertainty, I think, on their end as to how to actually address this, and that maybe, I'm speculating, but I don't know why there wasn't a hearing called up until this point.
Okay, well, I appreciate it, and I have a question for staff then, too. I think you're finished with your presentation, correct?
I think so. Like I said, I was hoping to give Eric Koenig maybe just a quick minute. He's, like I said, he's the litigation counsel, and
Well, I can't say to that because it depends on the
Yeah.
time that we have allotted and whether or not the chair approves.
Sure.
My guess is, but before that happens, I'd still like to ask staff some questions before we
Sure.
go forward, if that's okay with staff, with the chair.
I would like to hear what the underlying issue is that's going on.
Well, and that's kind of what I'm trying to get
Yeah,
at with
okay.
staff. I wanted to ask staff a question about it,
All right,
too.
you ask staff a question, then Mr. Remmer.
sure.
Okay.
And if I could, real quick before we do that, I think it's just these very specific issues. One is the foam paneling being up in a manner that we're all on the same page about, and the other was the interpretation of this note. Once the city legal department and the full, or late
Well, let me
fall
get to a
told me-
fuller picture, because I think
Yeah.
we're all a bit confused on everything. So,
Sure.
and that's, let's not start diving into the weeds right now. We've already heard a lot of weed
Yeah.
talk. Excuse
Have
me,
we?
Mr. Cohen. So we've already heard a lot about, being too deep in the weeds right now. I wanted to get my staff to find out.
Sure.
Yeah, the weeds Sir.
I'm gonna see who's gonna answer this question, so I'm gonna start with you, okay?
All right.
So, all right, we've been hearing a lot of stuff, first of all, about, barriers and this and that, and then, at the end now, somebody else is an owner of just this one parcel that's within, the Jason Accardi's property. So what I need to know is, A, who's being cited for what, when, and, because we heard Ms. Coyle come up before, but we don't know if it's going to the owner of the building, it's going to the owner of the patio. What's going on here? Because we need to figure this out.
So, my understanding from all the testimony I've heard is that Franklin Manor opened in 2016. At that point, they received an alcohol sign-off that only signed off on the square footage that they were allowed by City Council to sell alcoholic beverages.
Clarify that for us then. Please clarify that. Does that include the patio portion of it in addition to the building, or is it separate in any way?
It is one alcohol permit for both the building and the patio.
Okay.
Both areas were measured and made sure that they met the square footage that City Council had agreed to in the special use permit.
Because the original special use permit was in 2011?
I believe that's correct, yes.
When in 2011? Was it under this council, or was it the previous council? Because I can't remember.
I was here in 11.
I'll have to-
No, but you were here though. Remember, you were here before us.
It's dated January 31st.
What is it?
But that's
Okay.
It depends on what time of
That's
year.
what I'm saying, yeah.
but I
It was in January of 2011? Okay.
January, February 2011,
Okay,
yes.
and the reason why, and Mr. Cohen and I both kind of looked at each other like, I don't remember zoning this. It's been a long while though, so I wasn't sure. So thank you for clarifying that. So the original, I guess it would be the special use that was done included the patio and the building.
Correct.
Did it have a designation that those two pieces were separate entities in addition to, separate landlords, in addition to who the tenant was?
No, it called out both as one permit.
Okay, so hence some of the issues that we keep coming back to, which is no one knew what was anyone else getting and somebody else didn't get it, so where are we on all this, So I wanted to make sure we did not, send something out and they received it and then just ignored it, because it does sound like there's a little bit of confusion there. Now, I'm not sure if it is, but it seems like it might be. So the second part of this is, now that we know that there are three entities essentially that are dealing with this, and when in 2016, when they got the application, the approval of the application as the nocturnal group, so that also refers back to the 2011 special use?
Yes.
Yes.
Okay.
Yes,
I just wanna make sure
that
we're-
is the special.
I just wanna make sure
use permit.
I just want to make sure. I want to make sure we get it all right on there. That's good. I'll ask her from now on. So, go ahead. I'm sorry.
Yes, that is their permit that each of the letters that they received referred back to and said, here's the site plan itself is the actual permit.
Right.
And the ordinance that goes with it is, gives the rest of the approval. But yes, everything that they received referred back to that document, and that is the controlling document.
And for me, for an administrative part of this, which means that someone has to be getting the notice. If it's just the building owner, if it's just the tenant, it usually is both, if I'm not mistaken.
You're correct.
And
Yes.
so, in this case, it would have been three entities should have been getting it, because, and it does not sound like, based on the testimony that was provided before, that the other owner of the patio, I think, made the comment that he had not received any notice. Now, I don't know if that's true. I just know what he was put into the record.
That is what he stated.
Okay.
However, I have the green cards that I will enter into the record.
Okay.
The owner of the building, the owner of the patio, and the operator, the nocturnal group, all three of those received the June 16th, 2017 letter telling them that they were in violation. All three of those received the November 16th, 2018 letter telling them that they were in violation.
Okay.
And my understanding is that the clerk sent them all a letter of the notice to be here today as well. So all three of those received every notification.
Okay,
Yes.
good. I just want to make sure we're clear on all that, because we had a lot of testimony come beforehand and not so. The last thing, according to the site plan, the original site plan, and the approval that happened in 2016, there were, the barriers were all supposed to be there as part of the site plan, correct? On the original site plan or not?
That is a note that is on the permit site plan, yes.
But on the 2016 permit site plan, not on the original?
No, it was on the
On the original.
2011, that is the only permit site plan, is that 2011 site plan.
Okay.
It is on that site plan.
All right, I just wanted to make sure that that was already part of the process, okay.
Yes.
Thank you, appreciate it.
Ms. Miranda.
Chairman, I just want to speak on trying to solve problems that this, no, just stay right up there, ma'am. Just solve problems that won't reoccur again on the same matter. As I sit here and I listen to 2016 and then 2017, and I realize that today is 2019, and I don't know about the other council members, I never heard of this until now. However, on the other side of zonings or liquor, alcohol, when you miss a yearly statement to come in, and I'm not against the city or anything else, I'm just trying to say, how do we solve this problem so it doesn't happen again? And you have this yearly report that you met the 5149, and those that don't do it sometime line up from one side to the other. And by the time they come back the second time, there's only 2 or 3 left, and they come with a check in the hand and they pay with a certified thing from the CPA. Am I correct?
Yes, sir.
Okay. So now we go into the fencing part. When you do land zonings and you hear and you try to work something out, you say, well, we want bushes. No, we don't want bush. We want a wooden fence. No, we want a chain link fence. No, we want a vinyl fence. No, we want a concrete fence. So you specifically specify what you want on the fence. And as I'm looking at this here, and that's why I asked the question of, and what type of styrofoam is that? Is it a 1/4 inch? Is it a 1/16 of an inch that you require? Is it an inch? Is it a 2 inch? Or is it a 3 inch? They certainly have a magnitude of differences when you're talking about sound. But yet, from what I gathered from the city's part, there is no regulation with that. Am I correct or false?
You are correct. What the condition states is that there will
So
be foam
do you
panels.
think that we ought to fix these things up in the future?
Unfortunately, that is what was stated in
I'm
the
not going
approval.
to this case. I'm talking about future.
Yes, yes, we try to be more clear.
So then I'm telling myself, as Mr. Suarez said, Councilman Suarez says, one owner, other owner, one liquor license. Is it cut down the middle? Or is it the liquor license covers both? It's very hard to understand why, and I'm not saying you didn't send out a notice, and I'm not saying they didn't sign it. But what I'm saying is, 3 years later, when from the first incident to now, that's 3 years. And nobody's heard anything about it. So now we have a case against something that could have been resolved if it was handled just like they handled the alcohol zoning on the 5149, which is part of that process that we go through on a yearly basis. If those things are in place, I think that neither one of the 2 owners would have been here, the proprietor wouldn't have been here, and all the attorneys wouldn't be here. I'm just saying that we have to adhere to the changing of times to make sure that the rules are in place so that these things do not happen again. And as I look at, and I tell myself, how did this happen? I have no answer.
If I may, counsel, I think you're
Certainly.
going to hear some more testimony about what happened in that time period between that initial 2017 notice of violation and today.
That's fine, but I still don't know how come we weren't advised so that this hearing today would have been never heard. We would have solved the problem somewhere along the line by calling them and says, you either pay a fine or suspend it, or we pass on you. But something had to be done. As the process goes in land zoning, and I'm not creating land zoning and alcohol zoning, there's a process in place where those individuals that are giving a citation have a right to make amends and fix it. In this case, 3 years, we don't know about it. I didn't say we could fix it. I said, at least we don't know about it. Possibly we could have come to an agreement and fixed it 3 years ago. But here we are today. And I'm not blaming you. Please don't take that way.
I understand.
I don't do that. But I'm saying the system, including us, should have been notified of what was going on.
Okay.
Thank you, Mr. Chairman.
Okay.
Thank you, and if I could comment on that.
Let me remind you, your
Yes.
time is up.
I'm
Okay.
sorry.
So, unless someone is asking you a question, your time is up.
Let me ask a question, if I may.
Okay?
When this process started in 16, did they give you a drop date to fix everything?
Well, the letter that came from the city was June of 2017, And that letter looked basically the same as the November 2018 letter. I wasn't representing Franklin Manor at that time, but the way the letter reads, it talks about the exact same two issues that we're here saying, you know what, let's move forward together. So it talks about the same issues, and it says, you know, remedy them or we will bring you to a hearing. Basically the same thing that's happened in November, and that's why I say I think we all have to understand there may have been some confusion between the parties that were involved, because I can't explain otherwise why there was no hearing. Franklin Manor, they were kind of pushing back and going, no, this is, you know, we're operating correctly, you approved us, and then nothing happened. Now, upon revisiting whether there were issues and learning that the city did in fact view this as an open issue, we were talking together. I mean, even before that November letter came out, we were sort of looking to city legal to say, yes, this is our opinion of how this note is intended to be interpreted or not. So we were working together on that and knew the letter was coming once they stated their position, but it wasn't unknown. I know I mentioned that Eric Koenig is here from the litigation and could speak to this, but one example is that there was testimony during one of those hearings that LaShawn Dock gave, where she was asked in November, are they in violation? Are they in violation or not? And her answer was, I don't know. And so there was, I believe there was a genuine question, even on the city side, as to what needed to happen here. And so that's
none of
the
the
part
letters
that's hard to
stated
explain.
A drop dead where you couldn't serve anymore.
No, I don't think the letter contains
I
that
don't know,
information.
I mean, I've heard of the letters and I
Yeah, I think
I've
the
seen them go
letter, and I can pull that. It says, therefore, pursuant to city code, so it lists the same two issues that we're here telling you today. We're close. We're close to working through those. So it says, after it names those same two issues, therefore pursuant to city code section 27-318, the associated alcohol beverage approval may be subject to revocation or suspension. Please bring this operation into compliance with the conditions of the approval, or contact our office to clarify the nature of the operation within 10 business days from the date of this letter. And so I can't say that I wasn't involved, but I understand that their belief was that they were operating in the same way they always had, and then nothing happened. And so from our perspective, it's kind of like, well, if there was a fundamental disagreement, I don't know why the hearing didn't happen then. But here we are, and I don't want to, it's confusing, but I'm trying not to focus too much on it, because the point really is that we got together in November, December, and the city, re-looked at the issue and told us they were going to move forward. And so we assessed our options and decided that this kind of lined up with Franklin Manor wanting to do a little bit of rebranding anyway, and felt like this was the right way to handle this situation. And they've worked very quickly and spent about $60,000 to change their outdoor patio configuration, take down a stage, have custom-made furniture put in, and remove all the, I showed you the photo of the speakers that are in storage.
Right.
So
Thank you. I think the chairman's looking at me like saying you should have never asked her the question.
What's that?
Yeah, okay.
Whether they were given a drop-dead date, the letter read that they were to contact the office within 10 days to discuss the issue. I wasn't there, but again, no hearing ever happened, and their position was that they were operating appropriately. So I can't explain why nothing occurred. I don't know what was going on between the parties, but normally I think you would have the letter, and then if there was a fundamental disagreement, you would be here at the hearing, working that out.
But there was no hearing, they never asked you to come in
No,
for a sit-down
there was no
hearing
hearing.
and knock-out, drag-out.
No, there was no hearing.
Thank you, Mr. Chairman.
This is the first time we've been at a hearing.
This is the hearing.
This is the hearing. This is the first time that we've been brought
I'm glad you brought up the
forward.
barrier, because it said, one of the things that was mentioned was that in 11, they were supposed to have a barrier. Was it specific, the kind of barrier?
It reads, upon construction of the outside terrace, the surrounding perimeter will be lined with decorative foam panels to trap excess reverberations.
And that was
And-
not done.
Well, the panels were up, but I provided photos that are from this
Yes.
week what we were told was that there were some pieces
Stop right
missing.
there. I saw the photos.
Yeah.
And I can understand when when it was not specific, that you had to have panels this size, this much meeting,
Right,
that is confusing. And then when
Right.
they point out that there's openings, you know, like you said, I saw that, and they were like maybe 2 inch or so
Yeah.
apart. I understand that, because we were not specific about
Right.
how that had to go up.
and I really don't
And
think
it's
you would
really,
see a
it's
note
really
like that.
important.
Yeah.
Let me see, read me the 2 violations on the letter, please.
Sure. In just a second. So it says, the fencing surrounding the perimeter area must be lined with decorative foam panels to trap excess reverberations. The required foam paneling must cover the entire fencing area between the fence post. And then the other item, says self-contained individual controls will be located within the cabanas so that music levels can be sustained at an appropriate level. Outside speakers are not allowed. Speakers are currently located on the stage and outside of the building. The speakers on the building are only allowed if they are individually controlled by the tables underneath each speaker.
Okay. So the paneling, when it said, what I want to know is, it's saying you're in violation of the paneling because it had to cover it entirely. What I want to know is that how it was directed from the beginning? Is that the direction that was there when they got the permit? How was it described that they were supposed to put up the paneling?
So all we had was the note, but my understanding from trying to get all of the background of what transpired between 2017 and now was that they had communicated to the city what they were doing. It looked very similar to what I showed you photos of, is my understanding. When we were revisiting this issue around November, the city pointed out that there were some sections that were not covered, and so we immediately took care of that. And I was saying today that Kathy mentioned the small gaps, and so we didn't really know that that was a focus of what we were talking about. We're happy to work with the city and make sure that everything is just, we're all on the same page about it. And what I wanted to say too is we're totally willing to say, let's, come back in 30 days, let Kathy come out to us with the site and make sure that every aspect of this is completely resolved. I think we're about 90% there.
I understand. All
Yeah.
right. Now, here's the other thing about the amplification. What I want to know from our staff is, we have certain parameters today on amplified music. Do they supersede anything we said that they were permitted in 11 about the amplified sound?
Kristen Moore, Legal Department. We have the noise ordinance, and the noise ordinance would apply regardless of the regulations that they had. So the noise ordinance is the noise ordinance. They have to comply with that. In addition to that, they have conditions on their site plan permit for their alcoholic beverage. They must comply with that as well.
What are the conditions?
The conditions are, the two at issue today is the requirement for foam panels, and also the speakers are supposed to be in cabanas with individual controls on them.
All right. Thank you. Is that where they're at today? That's what I'm gonna ask you.
Yeah, so I would describe us as being in transition, but very close to complete with this transition over to what the city has told us they believe is necessary. We have all of the cabana furniture is up. There used to be a stage, it's been taken down. The big amplified speakers, they're all gone. We're expecting the next step will be to install the speakers that go in the cabanas, that we're hoping to have the city come and, come on site with us and make sure that we're, again, all on the same page about how those function. It's, like I said, it's kind of a strange note, and I don't think that we would see that note on an
You are well
approval
aware
today.
of how I feel about amplified music outside. But I will tell you this, we have people complaining about our Curtis Sixton Park events and the
Right.
noise that, and we haven't cited anybody on that, but that's besides the point. I just want to bring that up because You live in the city. Now, I don't condone, amplified music is just way over the top. But I will point that out because that has, occurred to me. I've had calls, I've had people come in about the noise of the train on the tracks, the noise of the park. So,
Sure, and
Thank you.
there were changes to the noise ordinance over the period of time that Franklin Manor's been operating, and I think that it's not what we're talking about today. It's not the
my
two
thing
issues,
is,
but it ties in.
why is it here today? Why didn't this come forward sooner? Why, I want to ask staff that. Why,
I can't
why
answer
are we,
that
Why are
question.
we, why, which is what Councilman Miranda alluded to, which was, why is this at this point?
Council, I'm
'Cause
happy
you
to
all-
address that if you would like. I
Yes.
thought that you might want to take public comment first, but it is up to you. I can address that, or you can take public comment.
No, I address that and then I'll be quiet for a little, I don't know how long.
You address that and then we're going to public comment.
Okay, at this point, I'm going to call as a witness in this proceeding, Mr. Steve Michelini.
Okay.
Please state your name and whether you've been sworn for the record.
I've been sworn, Steve Michelini, 2407 Sunset Drive. I was the one who obtained the original approvals for Franklin Manor, and immediately following the notice letter that went out in June, I was engaged by Franklin Manor and the landlord to resolve the matter. They were well aware of what had to be done. I started meeting with the city staff within a day or so with LaShawn Dock and with Kathy Coyle and with Gloria Moreta to try to resolve the matter. And those discussions went on for 7 months. And the whole time during that 7 months, from June until January of 2018, I was engaged to try to resolve that, and I went back. The panels that you're talking about were to be engineered by a sound engineer. They allowed, Kathy Coyle came out to the site and she allowed panels that were temporary in placements to be put on the fence. And then she came back out and said, well, it's not enough, but I'll let you go on as a temporary measure as long as you commit to resolving that problem. Franklin Manor owners were there at those meetings. They were there with me in the field along with the architect. So to say that they didn't know simply didn't happen. They knew from June all the way through January of 2018, I'm sorry. There are numerous emails from me to the tenants, begging them to comply, begging them to give me plans, to meet with the surveyor, to meet with the sound engineer, to come up with a plan for mitigation. It never happened. And in January of 2018, they sent me a letter saying, we don't need you anymore, we're gonna hire our own attorney. And I can share those emails with you if you wish, but as late as March of 2018, I implored them to get with the program and get these measures corrected and to address them. There was no such thing as we didn't know. They knew. They knew personally because I talked to them. They knew personally because I emailed them. And they said, and then they even emailed the landlord and told him Steve Michelini is handling this. That was in June of 2017. So, I'm also been subpoenaed as a witness in the court case involving them, where I gave exactly that same testimony, and I'll be happy to give it again and again. That is what happened. They were to hire a sound engineer to determine what the size of those panels were and how to mitigate the sound. They never did it. The architect told them to do it. They didn't do that either. So I'll be happy to answer any questions. As I said, I begged them month after month, week after week to come into compliance.
Mr. Michelini, I'm showing you a stack of emails. If you could briefly take a look at those and let me know if those are the emails that you had back and forth with the operators of Franklin Manor.
These are. Some of the responses to my emails asking them to comply are filled with expletives about we're not going to do this, we're not going to do that, and It wasn't for lack of effort. And you know that when I appear in front of city council, you take me at my word. I am a sworn advocate for various projects, and I don't take that lightly. And so when I come back to you and I say, I tried, that means I did try. I really tried.
All right,
Mr. Chair,
yes, sir.
there's clearly something missing in this story.
Yeah, there's a,
And we've got to find out what this, I mean, this is not the whole story that we've been told. We have to hear the whole story, and I don't know where we're gonna hear it,
Maybe
is
we-
more of it. Somebody's gotta tell it to us.
Maybe we'll
May I
find
ask
some
a
of it in public
I
comment.
gotta see something.
I think we might find some of it in public comments.
Regarding the panel,
So, I mean, going forward, if they want to comply, it's
And then I
fine.
wanna say
But,
something.
but that's not speaking to the issue regarding what they were charged with and their response.
All right, we got your point, we got a public that is sitting at the word to speak, and we need to allow them to do so.
Ju-
I'd be
just very
happy to
quickly,
answer any
since they're
questions.
both here,
And me.
if I may. I asked a question earlier about fencing and styrofoam 25, 30 minutes ago. And the counselor agreed that it was just not an eighth of an inch, a 16th of an inch, or 3 inches or 4 inches deep depth and whatnot. And now you come, Mr. Michelini, and possibly correct, say they were told to hire a sound engineer,
They were.
but I've never seen anything like that.
The panels that were
The
put up,
counselor for the city tells us that I was correct in saying that we never told them what kind of panels to put up. You can rewind the tape and read, and I'm not blaming you. You didn't know, neither did I, neither did the rest of us. So now we have conflicting interests on the sound barrier.
well, they-
Councilman, I may be able to clarify, if I could briefly. With respect to the foam panels, their alcoholic beverage permit states that they have to have foam panels. It is not specific about the depth of those, the color, what they have to look like,
Let me ask
nothing
you,
like that.
should it be?
I wish it did. I
Well,
wish
that's what
it-
I'm saying.
Yes, I wish it did. But they have sort of two issues going on that I think Mr. McLeany was involved in. One is that they have to come in compliance with their site plan. Number two is that they have to be in compliance with the noise ordinance. For the purpose of the sound engineer, I think that was to address their noise ordinance violations.
and the panels. When I met with staff, and the city attorney was not involved in those meetings, when I met with LaShawn and when I met with Kathy Coyle, they've also brought one of the building inspector, one of the reviewers into that meeting and said, okay, how do we deal with this? Because the notes were not that specific. And I was looking for solutions for Franklin Manor. And they said, you need to bring in a sound engineer and you tell us how you're going to mitigate the sound based upon the condition that was on the site plan.
Okay, I need to ask a question. I really do. So, may I? Yes, okay. They said you had to. Did they write it down that you had to? Another thing is, you threw in a court date that you were subpoenaed. Now that's a whole other,
That's a different matter. I mean,
yes, exactly, and it just slipped right in.
well, I mean, I was required to testify in front of the courts, the circuit court regarding
I don't-
a
no,
complaint.
no.
I'm not talking about that. I'm just saying, the information that the city attorney's office requested is the same information that the court requested.
Okay, I'm done. Thank you, Chair.
Clarence
Thank you.
Darrow couldn't solve this one.
All right, anyone in the public wish to speak on item number 57, please come forward.
Before you get into public comment, Julia Mandel, I'm here representing the building owner, Mr. Riccardi, and 912 Franklin LLC. I think it would be appropriate to allow us to have some rebuttal on the testimony that just occurred. But and keeping in mind, we're the landlord, and so a lot of these have to do with the tenant rather than the landlord. That being said, the landlord, becoming aware of all this, did tell the Franklin Manor folks they need to come into compliance. There's obviously confusion. They're almost there. Hopefully they'll get there. It would seem to me that it'll be appropriate to potentially give them 30 more days to come into compliance. And I'm here to say that if that doesn't occur, the landlord may also have some remedies under their lease. So there's litigation happening, there's a lot of other stuff happening, and I have a sense the two are getting conflated. And I think your goal is to get this business in compliance, as it always is in code enforcement and other matters. So, but that being said, if there's going to be an opportunity to have rebuttal afterwards on the commentary of Mr. Michelini, I would like to take that opportunity. Thank you.
All right, anyone in the public wishing to speak on item number 57, come forward. Have you been sworn?
No, I have not, sir.
All right, if you plan on speaking, or think about speaking, please stand and be sworn in.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And Mr. Chairman, may I remind all people who are speaking pursuant to council's rules in such matters, all persons who provide testimony, information, or opinion regarding a petition in a quasi-judicial matter such as this pending before City Council must disclose any direct or indirect business or personal interest between themselves and the petitioner or applicant which is requesting action. The information shall not be used to deny the petition or matter, but goes to the weight of the evidence, information, or opinion provided. So please do so. Also, if you are speaking at the direction of a party, please state that as well, because if so, that is counted against that party's time. Thank you.
Thank you to each and every one of you. My name is Joe Parrish. I'm a resident of 915 Franklin, which is apartments directly across from Franklin Manor. I will say that the special use permit is supposed to mitigate the reverberation of noise. I think that's actually the purpose of that special use permit, and it is failing miserably. From what I have seen, the paneling I think is a 1/4-inch foam. It has not been designed to stop noise. You can clearly hear the noise even up into this weekend over 100 feet from the property line, which is in violation of the noise ordinance here in Tampa that is now in place by Mayor Buckhorn. I had a police officer come to my house. He actually witnessed and put in his report that there were reverberations and vibrations of my windows on the 23rd floor above Franklin Manor because it was so loud. That is in a police report. So it shakes my windows. It keeps my kids up on weeknights before they have to go to school. The explicit language, by the way, that you can hear and clearly hear has expletives, which I have the lyrics to right here. If you would like to see, I made copies for each of the councilwomen and councilmen. Would you like to have the lyrics? I actually have a videotape of this song being played in which you can clearly hear the lyrics. As that is being passed around, I want to say that there are more complaints than just myself, but there are people that are afraid because Franklin Manor has created a situation where people are afraid to come forward. Why? Because when we complained to the police and became public record, they sent myself and someone else a glitter bomb in the mail, and they also sent me feces. So there are several people out there that are afraid to speak up against Franklin Manor. As far as business downtown, first of all, I choose to live downtown because I like to be in the middle of everything. That's true. Occasional train going by, an occasional siren, an occasional loud car, but not consistent pumping of explicit lyric language into my house in which I have to listen to it constantly over my television, over the white noise machine to help me try to sleep. That is not something that I considered whenever I lived downtown, and I don't think anybody would consider that. And so whenever you start to limit the amount of people that live downtown, that's what's going to affect the business downtown. It's not going to be shutting down Franklin Manor. It's going to be keeping people from moving downtown. So that's the business concern. It's not what these landlords want their tenant to keep paying their rent. It is for residents to move downtown and actually support the businesses that are downtown. So that's why we choose urban living. I know that I'm out of time. If you would allow and ask questions, I will be free to answer them. And I thank you very much for the time to comment.
Thank you.
Thank you.
Next speaker.
Good afternoon, Council. My name is Jerome Hagley. I'm with Carter, which is the general partner for 915 Franklin Street owner. We are the owners of the apartment complex directly across the street from Franklin Manor. We've been working with the city since 2014. We brought a significant investment to this part of the city, well over in excess of $100 million. We've worked with the city on several matters. We followed the rules, and that's all we're asking is that we have all businesses are held accountable for following the rules. We've mediated with the group across the street. We've met with them, and promises are made and promises are broken. And I hate to steal a phrase that my mother used to always use with me when I didn't do what I was supposed to do. Actions speak louder than words. We have a fiduciary responsibility to people that live at 915. We have to provide them a quiet and peaceful home, and we cannot do that with the rule violations that have been broken. And so I'm just standing here and asking you is that everybody be held accountable. I mean, there seems to be a lot of confusion here, but there's really no confusion from our side in terms of what's supposed to be done and what's currently happening. Thank you very much.
Good afternoon, members of the council. My name is Malka Isaac. I'm the mother of E. Michael Isaac, who spoke earlier. Michael and I own the corporation that owns the patio. First, I want to apologize for the misstatement that we didn't receive notice. My son didn't receive notice, and he's also part owner. I'm the one who received the notice, and I have a sick husband, without getting into details, but he took all the mail and destroyed it. He's demented, and he thought that it's a driver license or so forth. So I'm apologizing for it. I heard the testimony of Mr. Michelini, and I can state to you unequivocally that I met Mr. Michelini today for the first time 15 minutes ago. I never knew of anything I heard about today. I never knew about it. When he said that he met with the landlord and informed the landlord, I assumed that he met with Mr. Accardi. I own the patio, and I never met with him. He never told me anything. I'm a small business owner, and I have lived in Tampa, or close to Tampa, but I own property in Tampa. I've been a good citizen. I'm the owner of small business. I've been paying taxes to the city of Tampa for 45 years. I used to practice law. I'm now retired, and I have employed many people in Tampa and gave them a living, and my payroll exceeded sometimes over the years many millions of dollars. So I want you to give me an opportunity not to lose my business. It's like David and Goliath. And what I'm asking you today is to give the tenant an opportunity to fix the problem, not to put us out of business. We've invested everything into it, and we've been good citizens, and please give me a chance to work with the tenant and do whatever is necessary. Thank you very much.
Excuse me. Ma'am, let's go.
Thank you, Council. Good afternoon. My name is Carla Saavedra, and I live at 1108 North Franklin Street, Unit 405, and I'm a resident of the residents of Franklin Street. We are 2 blocks north of Franklin Manor at the corner of Franklin and Royal Street. And I am in an urban living. I chose to move downtown with my husband. We embrace all of the restaurants and the businesses that are here. I do not have a problem with what they're trying to accomplish. What I'm asking you today is to hold Franklin Manor to the law regarding the noise ordinance. They have repeatedly violated the code, therefore their privilege to serve alcohol is in jeopardy. This privilege to serve alcohol, it is a privilege to serve alcohol, not a right. With the privilege goes the responsibility to follow the law. And that is all that I am asking. I am happy for them to be downtown and have their establishment. Everybody in this country has a right to do that. I'm just asking you all to please enforce the law, the code ordinance. Thank you.
Good afternoon. My name is Sarah Rose, and I represent Bell Partners. We're the property management company that runs the day-to-day operations at 915. That's the apartment community that's located directly across the street from Franklin Manor. I would just like to state that the loud, raucous, late night music emanating from Franklin Manor has not only hurt our business operations, it's been very difficult to lease apartments and retain our residents. We've had to make a lot of concessions monetarily, transfer people, let them out of their leases due to the loud late night noises. And it's not just on the weekends, it's Monday through Friday as well. So additionally, we are constantly fielding resident complaints. They're very tired folks, and I know that it's damaging their careers and their lifestyles. So I'd like you to please take that into consideration. Thank you.
Good afternoon. My name is Ethan Loeb. I have a sheet of individuals here that have yielded their time to me. I think I'm supposed to hand this to you. Oh, sorry. Apologize.
Mr. Loeb, before you begin, will the following people please acknowledge their presence? Tyler Hudson?
Here.
Thank you. Joshua Colon? Here. Lexi Armini? And John Tasso? Okay, that's 4 additional minutes for a total of 7, please.
All right. Thank you for giving me the opportunity. I represent the apartments in the litigation that's presently pending in front of Judge Holder right now. I've had the opportunity to look through all of the documents that we've received that has been exchanged. I'm not going to bring all of those to you today because it fill this room. What I am going to do is share with you some of the choice documents to help fill in the gaps, some of the questions that you've been asking. We know that Franklin Manor received notice from the city in June of 2017, and as Mr. Michelini said, he promptly told them, you need to come into compliance. The response that was received and that the ownership group told to the Accardis, I'm not going to say it out loud, but it's highlighted and I'm going to make it part of the record. That was the first response. What happens next? Mr. Accardi, recognizing that there's a significant problem with the city of Tampa, writes to the ownership group and tells them, come into compliance. Time is ticking. There was a question, was there a time given? Absolutely, it was 10 days for them to come into compliance or make repairs and changes. And it was very simple. The foam paneling, but more importantly, take down the outdoor concert venue that they had set up. They had an outdoor stage with nightclub speakers pointing directly at the apartment buildings, speakers on the side of the building blaring, and speakers everywhere else. No cabanas, no sound controls. What happens next? Mr. Michelini continues to press and say you need to come into compliance. Why is that? Your city staff wrote to Mr. Michelini in October and told them the speakers have to come down. They are not part of the approval that allows your client to operate. That's what your city staff told. What was the response that the ownership group said? A responsible business owner in this city, and I live here, this is my city, I would expect you to say, yes, I will come into compliance. You know what he said? The owner, who's not here, by the way, he's absent. My liquor license or my business was on the line, I'd be here. Guess what he wrote? He wrote that. It's highlighted. And you know who he's talking about? Y'all. He says, let y'all take him to court. Don't do anything, just keep delaying. What happens next? Miss Doc, again, a week later, writes back to Mr. Michelini and says, has Franklin Manor removed the outside speakers? What does he say? Steve, I'm not removing the speakers until every other bar in Tampa does as well. Wow. That's a great position that you want somebody who's running a business in this downtown corridor that y'all are trying to make good. That's the response that's given. Mr. Michelini goes on and tells them that a delay is a bad bet. We're in December of 2017. Mr. Michelini, thankfully, is not the yes man to these people, and instead is telling them, you need to come into compliance. What do they do in response to that? Do they say, okay, it's been 6 months, time is up, we will do this? No. What do they say? Pardon my French, but they say it's time to cut the bullshit from them. And he says that y'all should give them a plaque and not bully them weekly. I don't know about you, but asking a business owner to do what's right and approved, responsible people respond and do that. What happens next? There's a change in the noise ordinance. Mr. Hagley, who appeared before you, wrote to the people across the street at the Franklin Manor and said the noise ordinance has now changed. It's a plainly audible standard in the central business district. And what happens next? The ownership group responds back to Mr. Hagley and says, in light of your recent actions, or lack thereof, I'm going to extend the same courtesy to you as you did with us with my future actions. What happens next? You heard folks come up here and say that there were no police citations or they didn't know about them. Wrong, false, absolutely incorrect. Multiple citations sitting here in my hand from the City of Tampa Police going out trying to address the residents' concerns because they can't sleep, they can't enjoy their balcony, they can't enjoy their kids, they can't enjoy their family. The one that I think is most pertinent for you to know is the one that happens after that email when Mr. Hagley's told that Franklin Manor is going to treat them just like the apartment owners treated Franklin Manor. Cops are called early in the morning, not at 10 or 11 when the park's going, when we all know that's life. This is it's like 1 o'clock in the morning. Police are out. Look what the bar owner does. It's disgusting. The bar owner comes out and learns of the violation, becomes irate, states he's going to turn his music all the way up now that his business is getting a citation, goes back in the bar and turns it up extremely loud with the speakers that are still there. So what happens? We go to court because the police can't get these people under control. They won't remove the speakers that they're not allowed to have. Judge Holder issues an emergency injunction, tells them to stop. Do they? No. They don't. Judge Holder has to modify the injunction and start telling them to take certain speakers down, point them the other direction. Is that good enough? You heard these people say they want to cooperate. They don't want to cooperate. They're just trying to be held, they're being held accountable now, and now they're trying to ask for you for their forgiveness? Wrong. And how do we know that? Council told you for Franklin Manor that there hadn't been any police activity since November. Wrong again. January 5th, this year, big party. Police go back out there and appear, and they issue a warning and tell them to turn it down again, even with the speakers taken down, as they say. And I'm going to show you in a minute, well, in 52 seconds, that that's absolutely false also, because there's still speakers out there today because we had a site inspection. There are multiple residents that cannot be here. I have their affidavits that I'd like to enter into the record. They're sworn under penalty of perjury, all of them singing the same tune. College students, elementary school principals, lawyers, business people saying, please, you have got to get this under control. The only way it can get under control is for you fine folks to hold these people accountable. Judge Holder has tried, the city of police have tried, my client has tried, I have tried. The buck has got to stop here. And so when council says there's speakers that are all gone, there they are. There's multiple speakers, there's 6 of them, still sitting there, all operational and all running. And so to suggest otherwise is wrong. I have petitions here from the neighbors. I'm entering into the record. They couldn't be here. All saying the same thing. Close this place down. It's over the top. I'm happy to answer any questions, and I appreciate your attention. Thank you.
All right. Turn those over to our attorney.
Yes, sir.
One quick question, if I could, Chair.
Okay.
Yes,
When
sir.
did you take that picture that you just showed?
The one I just showed?
Yeah, when was that?
We had
Because
to-
you said you did a site visit, I assume it's because of the court.
10:30 this morning.
Thank you. Appreciate
Yes,
it.
sir.
All right, anyone else wish to speak on item number 57?
Just a few comments.
Okay, good.
I believe some of those emails are the ones that Yes, sir.
All right, you wish to speak? All right. Go ahead.
Hi, Tracy Schamberger. I'm a 3.5-year resident of downtown. I came to meet the owners of Franklin Manor by being a resident downtown. When I approached them for a charity event that I co-chair and asked them for a donation, they agreed generously and helped us raise money for a very worthy charity 2 years in a row. thought Franklin Manor was a welcome addition to downtown. That north end of Franklin Street was very dangerous. Nothing was down there. I was afraid to walk that way. When they opened, that kind of made it a little more safe because there was a lot more foot traffic. I moved in closer proximity of Franklin Manor, and knew what I was getting into. I've never had a problem. I think it brings livelihood to that neighborhood. There's still crime in that area. There was just a murder in the park 2 months ago. So I think having a business down there with the other restaurants opening as well is just making that better and safer for the residents of that area. I just think shutting this business down with their generosity and growth of the community is just, it's not a good idea. I think it puts a bad look on the city of Tampa. So,
Thank you.
then you have a question.
All right. If you plan on speaking and you're able to stand up against the wall, we need you to do that because we were about to move to another section until these people popped up. So, all right. So let's move forward.
Alan Kapustin, ladies and gentlemen. I am a member of the Nocturnal Hospitality Group. I have been with them since the inception of Franklin Manor. I am one of the opening bartenders of that concept. I have opened the 2 other concepts they've had since then. What I can say about the company is that it's one of the best businesses I've ever worked for. They're very hospitable, they're very generous. They do toy drives, food drives, dog adoptions on Sundays for dogs that were rehomed out of from the hurricane in Puerto Rico. They really put the community first, and they put us first as friends and as family, and I'm lucky enough to call them my family. Dave and Franco, they've taken me under their wing, and they've really taught me the hospitality industry and the hospitality business and how to be generous and how to be hospitable to the community around us. We love our neighbors. I have lots of friends that live in 915 that aren't bothered by the sound, and then there's people that are, but I can't call to how that building was built, but it came up in less than a year, and we were around for a year and a half before the building was even, the ground was even broken. So I love the business I'm in. I love working for these guys. Things can be taken out of context, the way people say. You can't, judge somebody's character based on that, but I love Nocturnal Hospitality, and they've done nothing but be right by me, so I have nothing else to say besides that. Thank you.
How you guys doing? My name is Michael Ackley. I am the general manager of Franklin Manor. And I'm here on behalf of me and the 50 employees that we currently employ at Franklin Manor. It's a great group of people that we work strongly every day in and out to abide by the law that you guys have for us. And we're not trying to make anyone feel uncomfortable being downtown. We're not trying to, cause all these issues that are being brought against us. We're literally trying to build downtown into something bigger and greater. And with the Nocturnal group and the people that we've brought into it, we feel like we are accomplishing that. And little by little, we are going to actually make downtown a great place that everybody wants to be. I would hate to see an establishment like Franklin Manor that was one of the first ones to be there get taken out, and we lose all those great employees that we have brought down there into that establishment. Thank you, guys.
Sir, you said you're the general manager.
Yes, sir.
Correct? So you must be the person that gets the noise complaints, right?
I just started about 4 months ago as the general manager. Since then, I had one complaint that I was there for that day.
So you weren't really there for the series of things that we're hearing about?
Yes, sir.
How did you handle the one complaint that you got? What did you do?
The one complaint, the officer came, and me and the head of security, we went up and we spoke to the cop, and he actually laughed and said that he thought it was a vindictive complaint because he couldn't even hear the music from the front door of 915.
So you didn't think the music was unreasonable to allow that particular night?
Absolutely not. Never got any sort of paperwork from the cop, nothing. He got back in his car and he drove off.
Thank you.
Thank you, guys.
My name is Gregory Zwolinski. I'm one of the original investors for Franklin Manor. I was approached in 2015 about this new concept, and I happily mortgaged out my car, my house, and really put my entire savings, my mom's savings and my wife's savings into this project, starting off a long time ago. I was criticized because that was a part of town that had abandoned buildings at the time. A lot of, people walking around there that maybe seemed less reputable. And 915 wasn't around then, but I got to be a part of the whole build out. And I worked very closely with the sound engineers on this project, and having an engineering background myself, I made it very clear to the city and zoning at that time that a foam panel fence wouldn't do anything, because sound travels in vectors. So as it bounces off the ground, travels up the building, you can stand outside at the front door, and it can be very quiet, but when you go up 50 stories up, it could be very loud. So a wood paneling or a foam panel per se is not gonna really help. The pictures you've seen today, one of the gaps was behind the stage, and then we put a food truck to try to block as much sound as possible. The sound engineers we're working with right now, they're expensive, but they're doing amazing work. I mean, the way they moved everything around, the cabanas and everything we're doing moving forward really has an impact on everybody around us. And I do feel like we're being very proactive at this moment on how we're going around that. This is really nothing short than a very passionate character assassination against the two owners. The building has investors it's got to answer to. It's a business plan that's not working out the way it was pitched, and they're looking for somebody to blame. So we're sitting here trying to be nice, and we're really trying to make ends meet. I mean, some of our staff, they're expecting, two of them are newborns, and one of them you saw earlier today. Shutting down a small business is really going to cripple the small guy, not the big guy over here. And things like this does scare away investors, potential investors moving forward to other concepts. I mean, I have people from out of town that want to invest in this town. They love the concept of Tampa Bay. But every time something like this is brought to the table that a business is to be shut down, it really dampers our efforts of bringing money in from outside industries or outside areas into the Tampa Bay area. Thank you.
Can I ask him a question?
No, me first.
Oh, I apologize. I didn't know.
No, because then it goes on.
Okay.
So, look.
Okay, go ahead.
All right. We're hearing a lot of,
You
what I
have to
want
forgive me,
to,
I'm-
no, I'm not going to
okay,
ask you a
sorry.
question. I'm going to ask staff. When's the last time we had one of these hearings here? When's the last time?
The last time you had a 27-318 hearing was last July, and that was for the R zonings. It's been a while since you've had one that was not one of the R zoning violations.
It's been quite a long time.
It's been quite a while.
I remember because we didn't
Ms.
close
Quill
it
may
down.
actually know the answer.
I remember, well.
It was
and I'm gonna tell you
Hollywood
what-
Nights.
What?
It was Hollywood Nights in 2013.
Exactly. And you know why we didn't? Exactly what they just said. People are employed, wholesalers, the whole 9 yards. But, that being said, that they didn't comply is very important to me. So what I want to hear from them is what they're going to do over and above the requirement. I want to know what time they're going to stop the music. I want to know, and if they're willing to put it on the site plan. That's what I want to hear. Yes.
Kristen Moore, Legal Department. Unfortunately, there is not a lot that City Council can do in terms of remedies. We cannot alter their site plan at this juncture. We cannot make any
I'm not
changes.
altering their site plan. I'm asking them to alter their site plan. Can they do that?
You can hope that they will, but
I can
we,
hope that they will.
We,
I'm
we
making
can't
a
require
statement
it.
that I hope that they will.
The only vehicle that City Council has for compliance, this is actually going to be a two-part. Is number one, find if there's a violation, and if you do find that there's a violation, you have the ability to oppose a penalty for up to 30-day suspension of the sale of alcohol. That is the only enforcement mechanism that you have at this juncture.
Okay. Again, the suppliers. And that's the same reason we didn't close Hollywood Nights. And that was horrendous. Horrendous. So now, as I said, I hope that between the owners of the property, the management of this establishment, come up with a plan that they move forward, that is over and above anything that we require. Because at this point, they're on thin ice. And, let me see what else. Oh, I asked you the last one, okay. And if I would allow 30 days for them to decide, not to decide, I want them to tell me today what they're gonna do and how, and because they have to do what we require. They have to do that, and we can hold them accountable, whatever fine, whatever you said we can do. But I wanna hear how they're gonna fix it, because when Hollywood Nights came up, they didn't tell us how they were gonna fix it. All they said was, all these people are gonna lose their job, and all the wholesalers aren't gonna be able to supply these people. And guess what? We didn't do it. So, I wanna hear. I'm really, this is.
If I could.
Yes.
Well, I've been asked by Catherine Coyle, Planning of Development, I've been asked by legal counsel, just to make a couple clarifications per number 6 on your list of, hearing procedures. For one, Captain Neal did contact us back, and there have been 7 calls to TPD for complaints since November 1st, 2018. I just wanted to get that on the record.
7 calls in the
7
last
calls
2.5 months.
since
Okay.
November 1st, 2018.
3.5.
The second thing, no, only if you have a question, that's fine. Just in clarification on Hollywood Nights, you did actually suspend them.
I'm sorry?
You did suspend Hollywood Nights. They did have to shut down.
How long?
It was 7 days.
Uh-huh, not 30 days.
That's correct.
We
With
did-
you have an option 0 to 30.
Okay.
The first decision you have to make is whether or not you find them in violation.
You're going next.
Don't need instructions.
If I could, I mean, I don't know if you're.
Yeah, I'm waiting, I'm gonna wait to hear from them. Go ahead, you add to it, there you go.
Well, yeah, you asked a couple of things, and you're right. We haven't done a lot of these. I do remember that we did reduce the amount of time for Hollywood Nights, and I think, if I'm not mistaken, I think Bar Atlantic was another one we had that was along Franklin, which is one of the older buildings over there that we shut them down for a while. But here's the question, and I'm asking staff. So, Mr. O'Donnell, you can just move away. I don't like seeing 2 people at the podium at one time. Okay, so. The options are, 1, we find them in violation, and then 2, the amount of time that we will suspend them. And we do have that leeway up to, how much, 60 days or 90 days?
30 days.
30 days, I'm
is the
sorry, 30
maximum
days,
for
right.
this first
30 days is the
violation.
top.
Yes, and on the handout that I gave you earlier, on the last page of it,
Yeah.
I spell out those 2 motions for
Yep,
you.
I see it there. Okay, so, but we're still in a situation where there's a lot of information that we received concerning discussions as to whether or not they were ever going to comply back in 2017. There's a lot of jargon and stuff like that. After all that information, we don't even know if they ever tried to comply. The second thing is that you have an investor of the company who's saying none of this matters, and yet. He didn't say that we should be doing this. And I think that that's exactly what Ms. Capine was saying, which is we have the ultimate hammer right now, and everybody's saying we're bullying them or that we're not treating them right, but no one's coming up with an answer. And that's part of the problem that we have right now. So I'm going to ask Ms. O'Donnell to come up, and you've heard some of this. Ms. O'Donnell, if you can come on up. You've heard what Ms. Capine has said. You know what our options are, okay?
Sure.
You understand that we're not shutting down a business. We're just holding them essentially in contempt of them not following what is already on the site plan. So if you don't have a plan forward for it, it's going to be a difficult decision for you all, not for us.
Right, and I think we're coming to you in a very different position than this other establishment that was referenced that was suspended for 7 days. We've come and shown that since the city told us in November, we're moving forward, we're gonna end up bringing this, we're gonna take this to the extent of having a hearing, and this is our position. We didn't know their position. I mean, we had someone on staff provide testimony in November saying they didn't know if we were out of compliance. As soon as we understood their position, we made moves. We're here showing you $60,000 worth of work that's already been completed. I think the only pieces remaining are that Kathy Coyle went out to the site today and identified some gaps that she felt should be filled in, and we, immediately said, we'll work with you, we'll figure that out.
Can
The
I
only thing
stop you
left
there
are
for a
putting
second? I
speakers
just
in.
want to stop you for a
Yes.
second. Okay. You made a statement, because I know you haven't been on this from the very beginning, so I'm giving you a lot of leeway. There's a lot of emails concerning from summer of 2017. Okay. I believe, and I may be wrong about it, I want to make sure I get this right. One of the people that is part of the ownership group is still in that ownership group, and he was one of the ones that was communicating with Mr. Michelini and then with Ms. Dock. Okay. And I just want to make sure I'm correct about that, because I don't want to disparage anyone.
Right, and I know there was a comment, there are several
Well,
comments I was
answer my
but
question.
some
Am
of
I
the
correct?
the
Am I
ownership is here.
Am I correct about that, though?
Yes,
That person is still part of
and-
the ownership group?
Yes, and Steve Michelini was not writing emails on behalf of the city.
I understand, no, but there were emails from Ms. Dock too concerning the situation. So, I mean, and she does represent the city. So, my point is that I don't want to have a situation in which whatever the time frame we come up with, or if we come up with no time frame, that we're going to have the same issue, and that there's going to be this attitude that no one's going to comply. Okay. Now, I know not selling alcohol is a big loser for any business that sells a lot of alcohol. Okay. But I don't want to be back here in 30 days or the next council in 3 months having to deal with the exact same situation. So we need some clarification from your side, and I think it'll give some comfort, because I think Ms. Capine put it pretty succinctly. Yeah. So I think that there's some aspect that we're going to have to know something, because
Sure.
this is not a good record for your side.
And I know we've said this a couple times throughout this very long discussion, that we're happy to let a window of time happen where we can get with Kathy Coyle on the site and let her see the speakers that will go in. I think that's the outstanding issue. Everything in these photos that you've seen, none of that existed a couple months ago. So there has been a significant effort. I think the equipment that was taken down was valued at like $100,000 of audio equipment. So this is being handled in a very, it's very fast, the changes that are happening, and we anticipate that we would have no problem in having some on-site meetings and wrapping up just the final questions, because I think all that's left are to put the speakers in and to ensure that the foam paneling is correct. And you have our word and our ask that we be given 30 days to just make that happen. Let us get with staff on site. We haven't had an opportunity to do that since these new changes
And I
have
think
taken
you understand
place.
that I'm not even sure, I'll have to talk to legal as to whether or not we can do that and set it off for 30 days, and that's something that we can ask. So you could have 30 days with alcohol or without alcohol.
Well,
If you understand what I'm saying, so
yeah,
it's
we're
a little
absolutely,
bit. Hang on, it's a little bit different to ask for permission now after we've got a record like this. That's the problem. Had this been a different owner, and it had not been a person that's already part of your ownership group that was sending emails back and forth the way that they were doing, I think you might have had clean hands. I don't think you do. That's part of the problem. And I hope you follow what I'm saying to you.
I do. And
Okay.
I think one thing that's difficult about, what we heard is that we have this litigation that's going on, and we have people who are interested in advancing the litigation agenda and sort of using this forum for that.
I can't help
So
you in the
you're
litigation.
seeing-
Just
Right. But my point-
get with us on this.
Yeah.
Let's
And
not talk
my-
about the litigation.
Sure, and my only point is that you kind of got a snapshot of pulling out from, piles and piles of documents, trying to find the absolute, worst looking email that could be pulled out of all of that. There are a lot of other things that were going on. Franklin Manor also had different counsel at that time, in contrast to emails with Mr. Michelini. We don't know what was happening, on that front. So I think it's a really incomplete picture, and we understand that, that it, may not sound great from your perspective, but we have taken some really serious steps to try to bring this forward, and we want to get on the same page immediately, as soon as possible with the city.
In fairness to us, we can only go with the record that's presented to us. Okay, so that's all I can tell you. Okay, thank you.
All right, Ms. Cohen.
I have never, ever been handed a pile of documents like this before in a hearing in this room. I am flabbergasted that the first thing and I realize you were not the attorney on the case when a lot of this happened, but this is willful noncompliance documented in a series of emails, thumbing the nose at the city. The landlord attempts to talk sense to the tenant and is rebuffed. And Mr. Michelini clearly, over and over again, is attempting to try to help remedy the situation and is rebuffed. And over a year and a half went by. I mean, honestly, I just can't believe that the first thing that didn't come out of someone's mouth was an apology, because that is what is owed to the community for basically saying, screw them. Worse than that, obviously. We're not going to do it. Let them take us to court. You know, we worked very, very hard on this noise ordinance, and we did it for a reason, because we get complaints from all over town about exactly this type of behavior. And you know, the landlord recognized it. The owner's own agent recognized it. And wow, I mean, it may be selective, but it's pretty tough stuff.
Yeah, and I know one of those emails I even saw that was flashed up on the screen says, you know, do we need to talk to an attorney? And so that's what I'm saying. There was more going on, but I actually, to your comment, we were going to bring up Mr. Lou Domer to speak on behalf of the ownership and just talk about, you know, where they are right now and how they're moving forward. And we would really appreciate that opportunity, because I don't want you to only hear from me.
I believe that you're moving forward in good faith.
Yeah.
I really don't have an issue with that. I think you are. I think you're obviously trying to remedy it. But the situation has gone on for a long time without being remedied, and the lack of clarity, I don't really see it. I mean, LaShawn Dock is asking, have the speakers been taken down? Have the speakers been taken down? Have the speakers been taken down? I mean, you know, how many, if they asked me that question, I would take the speakers down.
And I think part of what makes this, again, really confusing is that what theoretically should happen if there was an impasse would be a hearing just like this. And I think that's part of the history here that's just, it's murky, and it is what it is. We're here now. This is the first time we've been called for a hearing, and we've made all of the changes with very minor exception. But I really would like the opportunity to have Mr. Domer speak.
No. We have a full agenda.
I understand.
And we need to wrap this up. Mr. Maniscalco.
You know, what is extremely frustrating is, you know, how Franklin Manor has turned around that area, because before that it was dead. And I appreciate it and I see it. But when you have a gentleman like Mr. Michelini, who has decades of experience saying, if you don't do this, this is going to happen. He knows the ins and outs of the city, how things work. He's been here firsthand. You have Mr. Accardi as the property owner pleading with them respectfully, hey, please get this taken care of. And I'm looking at the dates 2017, a year and a half ago. It's not a matter of, well, they can't afford to make the improvements. You know, they just don't have the money. It's blatantly, as Mr. Cohen has already mentioned, you know, thumbing their nose at the city. You know, go ahead, you know, sue us, this, that, whatever the language was in these emails. When you have residents across the street and around the area complaining about this could have been avoided. This should have been avoided responsibly as adults and taken care of in a different manner. But I mean, the emails speak for themselves, and once again, it's frustrating because I appreciate everything they've done. There, the restaurants up the street and whatnot, it's turning around Franklin Street. But we have rules and codes and regulations that are not just for these business owners, but for everybody, and we have to enforce those. I mean, it's simple. If I were in their position, I'd be losing sleep at night trying to come into compliance, especially when Mr. Michelini, once again, because he has the experience with these cases, is saying, if you don't do this, there will be consequences. And here we are at this hearing in 2019. This should have been avoided. We shouldn't be wasting our time on this, and now we are. So.
All right, Mr. Miranda.
Thank you, Chairman. On June 24th of the year 2017, one of the proprietors of the building wrote them specifically to this and asked them to get it happy before the city shuts you down. Thanks for the time, and the time is clicking. They did this. The hell with you. To the owner, they said that. Who are your clients? Do they have? They're great restaurateurs. But they must be stupid. No, I'll tell them to their face right here. I'll tell them, you guys are stupid.
Well, I'm happy to
no,
let you
I ain't
hear-
finished.
Yeah, sure.
We had 3 years of this, and I blame the city in partly for not bringing it in closer and sooner. That's why I was getting to it earlier when I was speaking about the city. We have to change our rules. When we talk about styrofoam or fencing, we have to say what it is specifically within the law. That's what we do for everything else. But this council, from what I see here, I don't know what to tell your clients. I don't know who they think they are. This is not Chicago, this is not New York, and this is not at the waterfront. This is not the Godfather. You understand me, guys? But this here is not going to be what the city of Tampa is all about. All this here, we spend more money, or they have, on attorneys today than fixing the place. I don't understand it. I don't understand what chip in the shoulder they're carrying. I don't understand it. I really don't. I mean, I met them yesterday for the first time. I said, these are two real nice guys. And I still think they're nice guys. Just power went to their head. And now they're paying with it through the wallet. You don't do business that way. You have this attorney trying to help you out, trying to solve the problem. The gentleman who came before you tried to solve the problem, and you blew them off. You blew the judge off, I guess. I don't know what the remedy is, but either you conform to them, and I don't care if you stay in Tampa or not. How you like that? You're not going to do business in this city in that manner. The Godfather's not here anymore. Thank you, Mr. Chairman.
Mr. Vieira.
Thank you, Mr. Chair. And I agree with the comments that were made. When I read these emails, the biggest thing I see is pride, 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 pride. I mean, and we know that pride cometh before the fall. And the sad part is that the fall is not just going to be sustained potentially by the owners of this establishment, but by the workers that we were talking about. You know, some folks were talking about I think it was the 40, 50 employees and distributors, et cetera. You know, when business owners act like this, they can take a hit many times. They have a lot of money, they're very affluent, et cetera. It's the workers that get the real fall. Whether they're out of work for a week, whether they're out of work for a month, whether they're out of work forever, it's going to be the workers and the employees. So I think that's, you know, whenever I hear to the extent that crocodile tears are being shed regarding the workers, the protection of the workers began right here. And when we see this kind of prideful and vulgar defense of the indefensible, the real victim's going to be the working families represented with this business.
And I don't want to interrupt, but I would say just one comment on this. The timing, I think the correspondence you're seeing that's kind of a snapshot of a bigger picture, it was a while ago, and I think I would love for you to hear from one of the owners about.
No, that person had, when we were doing the public comments, that person had the right to come up and speak during those 3 minutes, and that person did not do it.
I know, because I told him he could come up during my rebuttal.
So we're going to Ms. Capine, and then we'll go to the 5-minute rebuttal for each person. Ms. Capine.
Yes, you know, everything that we got is, you know, I learned something in junior high. Never put in writing what you're thinking at that moment, ever. That was junior high. So, that being said, you know, as far as crocodile tears about the workers and it really is true. It really is true. You don't only hurt the owners. They got money. You're really hurting. It's really a very deep schedule of people along the line that get. So, as I said before, I wanted to hear from you and your people what over and above. I don't want to hear we're complying. I want to hear what you're willing to do to really get this and make friends and be really good stewards of this city. Now, I understand this was the first place that went down in North. As a matter of fact, I'm going to tell you something. You know that patio? It's right on the corner. There was a building there. and it got torn down. I had a restaurant in that building in 1980, 81, called Uptown Cafe. So you know, I invested in it, let me put it that way. But that being said, I know the location, I know the whole area. It's really, what has come up here, and you know, you said that, too bad we didn't have a hearing. Well, you're having one now.
Right.
This is what's happening now. So we have 0 to 30 days suspension. One of the things I'd like to maybe see is continue this for 30 days and come back and see what you do with the owners of the buildings and the management.
I think they would be really, really grateful for that opportunity.
I'm sure
And
they'll
happy
be,
to
I'm
let
sure
them-
they'll be
I'm
very
happy to
grateful.
let
I
them
am
speak
sure of that.
directly to
But
you about that, but I think they would be
let's see what
very
we have somebody standing up, we
pleased
gotta
to see
talk.
that opportunity.
If I can make a suggestion, City Council, Kristen Mora, Legal Department. As I mentioned earlier, there are two parts to what you have in front of you at the conclusion of this hearing. My suggestion would be that you might want to go ahead and make a finding on the first motion, and then if you would like to wait 30 days, that might be more appropriate for the second part of that motion.
Okay. Yes, sir, I see you.
If I can, Counsel, and also for
Yes.
purposes of the record, I understand, Councilwoman Capino, and I respect what you're saying with the over and above. Just for purposes, and certainly, that's been communicated to them, and they can certainly come back within 30 days. If 30 days is sufficient for council, if you wish it longer, that's fine too. But my point is that it should not be or taken in the form of an exaction. That in order for them to get the mercy of this
Right.
council, that they have to do
Right.
something that the code does not require them to do.
I understand.
That they're doing it out of duress, perhaps. So I know what you're asking for, but I just want to make it clear that council does not have the authority to go in that direction.
Right.
That does not mean, because you will not base your decision based solely on that at all.
No.
But that doesn't preclude them from still doing the right thing. I understand what you're asking.
Right, and we are in a position from the very beginning of this very long discussion of saying we want to be on the same page, we want to move forward. And so I appreciate those comments, but we are, here trying to do right.
Should I have to do the first motion? Tell me what we need to do.
If I can.
Okay, yes, okay, yeah.
And before we get to rebuttal, there's one other item that I want to do of housekeeping, and that involves Councilman Vieira and Councilman Maniscalco, because you were out of the room at the time, with regard to ex parte communications and disclosures. Is it my understanding that neither of you have met with anyone involved in this case?
I have not.
That is correct.
Okay, thank you very much.
Okay, we'll go to rebuttal at this time. Each of you got 5 minutes.
Excuse me, may I ask, Ms. Mora, is rebuttal also for 5 minutes per party as well, or are they splitting that as well? I don't know what the decision
The
was.
form here say 5 minutes.
My suggestion would be to split it, but I'll let council make that decision after speaking with the.
When you say split it, you saying this 1 5 minute split it to 2.5?
Or split in whatever manner they would want, but yes, 1 5-minute period would be my suggestion, but you can talk to the parties if they think they need additional time, then they can address that.
She's a property owner, she wants to speak as well.
Okay.
As part of the rebuttal, she's a property owner.
Sure.
Okay, but ma'am, please, hang on. There's a 5-minute rebuttal period, that is for everyone.
Okay, very short.
We could extend
Councilman Cohen and the rest of the council, I want belatedly to extend an apology that you have asked for and didn't come forth. So my apologies for the behavior of what you have asked. As a landlord, I can assure you that I'll take the necessary steps with the tenants, whatever the law allows me, and I will give them an ultimatum that either they comply with what you require or else they cannot stay on the property as my tenants. Thank you.
I'm going to say one thing, if you don't mind, take 1 minute, real quick. Yeah, and on behalf of our partnership as well, I will make sure that as of today, they're going to become compliant, or whatever provision within our lease and the Florida statutes and laws we're going to comply with. So we are going to work with our tenant to make sure they're in compliance. Thank you.
And I think you all have heard enough from me, and I'm just gonna let Mr. Domer come up and speak since he hasn't had a chance yet, and I think then we can answer any further questions, but I think we're...
Hi, my name is Lou Domer. I'm a visionary. I believe in the city of Tampa. I am not part of the ownership of Franklin Manor, but I do consult with them on that particular portion. I am part of the investment group that is Osteria, Mole Buele, and soon to be one other venue that we can't talk about yet. What I can assure you now, and since I've been a part of the last statement that was given by the city, or the last notification in November, that we have been working diligently to make those changes that are required to actually comply. I like the fact that looking at the ability to exceed what you guys can expect from the Franklin Manor. I will do everything in my power to make sure that happens, along with the landlords, so that it can remain a viable entity and a good part of the city of Tampa. Because I believe, even under a new format, which is already changing, that it can be an exemplary part of what we're already doing for that part of downtown Tampa and making it a destination point. Do you have any questions for me? Okay, thank you.
All right.
Take 60 seconds of your time, if you don't mind. Councilman, my name's
How
David
much
Anderson.
time left on that clock?
I'm sorry?
Okay, all right, go ahead.
My name's David Anderson. I am one of the managing partners of this business. Franklin Manor was put together on 2 years of begging for money at coffee shops. We built it with a shoestring budget. I am not from a family with money, and that's all we had. And now, luckily, the little bit of success it's had is drawn on the celebrity chef Fabio Viviani, and we're opening these other concepts. A lot was said today about the sound issue and boards and experts and et cetera, et cetera. If we had another 5 hours, you'd hear a lot more of how we have hired an expert that used to do the Mid-Florida Credit Union app, and he was in litigation with us, and we dropped about $12,000 that we don't have on that. Currently, we've spent roughly $60,000 and to fix the outside there. And you asked what we're going to do above and beyond. Well, all the large speakers are down completely. There's only going to be small speakers inside those cabanas, which were also on that site plan, which we've also had built in about 2 weeks somehow. And like Catherine said, really it's just a foam board issue, and I think we'll be in full compliance. So I urge, hopefully we can work with the city and they can do a site visit, and we can remedy this probably within 14 days. That's really all I'm here to say, so thank you for your time.
14 days.
And the very, very final comment, I promise, is that we realize the notes on that 2011 site plan are not the most artfully crafted, and they leave a lot of ambiguity. Again, we had foam decorative paneling. I think these are some of the things that we can talk about with city staff if we're given the time to do so, and make sure, again, we're on the same page.
Just one question.
In addition to being in compliance, are you also warranting to us that you will no longer violate the noise ordinance?
That's my, I would rather.
I mean, I don't know that you're allowed to say that you won't break the law, if it means anything. But I'd like to hear on the record that you're committed to not being in violation of the noise ordinance.
They are very committed and have spent a lot of money on a noise expert to get themselves in that place. And you've heard that there were calls post-November when a lot of these changes took place. There have been no citations since that point. So I think you're seeing the commitment, but we're just kind of, I think we're at the final stages of getting the site in a place where the city agrees that we're compliant with the site plan.
I'd like to make my motion.
We got
more? There's more time? They got more time?
Right, we can't say we're not.
No, sir, you through.
Okay, fine.
All right. Ms. Mandel, she want her rebuttal time?
I'm sorry?
No, not you.
I'm sorry.
Julie Mandel, I think Mr. Riccardi said all of the rebuttal that we need at this point in time, and I think proceeding forward with the knowledge that both owners of the property are also going to be doing the best they can to assure compliance with the site plan, I think should give council some comfort because they have been trying to do that. Thank you.
All right, can we get a motion to close the public hearing?
So moved.
Second.
We got a motion from Mr. Miranda, seconded by Mr. Maniscalco. All in favor of that motion, say aye.
Aye.
Opposed? Mr. Payne.
Yes, as far as the first, it's for sure they were in violation. That we have to move on before we move on to what we find and what we determine the penalty to be. Is that correct?
Yes, and to also reiterate what Ms. Morris said to you in front of you, on the last page you have the first part of this hearing. So you have to then make this determination. The sample motion is on your screen as well.
That's what I'm looking at.
Okay, and I just ask that if you choose to adopt that motion that you recited, obviously there's a choice to make as to whether they have or have not, and you would choose the appropriate decision.
She said that it was part one and then part two.
Yes, but in order for you to get.
Right, that's what I'm looking at.
Right.
Exactly. Yes, right.
Find the violation first.
But then the second part would be another motion.
That's
Or
after the
it's
first.
part of
That's
the
after
panel.
the first
Right,
one. That's
after the first part.
motion.
That's the way I understood it.
Thank you.
Okay. Well, I make a motion that after hearing the evidence presented at this public hearing, City Council determines that Section 27-318C1 N has been violated by the property owners, holder of the alcoholic beverage license, operator of the establishment, and any agent or employee thereof. Specifically, that the conditions, limitations, and restrictions imposed at time of approval identified by staff have been violated.
Second.
All right, got a motion from Ms. Capeen, seconded by Mr. Miranda. Any further discussion on that motion? All those in favor of the motion say aye.
Aye.
Opposed?
Okay. Now, my second, the penalty, the gravity of the violation was, grave, yeah.
Life support.
Was grave. But here, and some actions have been taken to correct the violation since then, and any previous violations. But what I want to say is, one of the owners came up and said in 14 days, they can correct all this. So in 2 weeks, I would propose that in 2 weeks, everything is corrected, and I want to know if there's any noise violation in between now and, or I suggest that we find out about that in between now and the
You
2 weeks.
gotta
Yeah,
come up with a
Ms. Capini,
suspension.
if I may ask that you start the 2 weeks starting tomorrow, because the day does not count.
Right.
Starts tomorrow, 14 days.
14 days from tomorrow, which tomorrow's the 22nd. Well, that was my father's birthday. Things pop up into my
Do
head
you
like
have to also
that.
include the suspension?
Well, here's the thing, Council, and Ms. Moore can come up and add to chime. Council, you have made a determination that they are in violation today.
Right.
If you wish to have a period of time for them to do whatever they wish to do, whatever assurances that they may give to you, to allow them to come back at a continued public hearing for the purposes of addressing number 2, the
Right.
second part, which would in fact be the penalty phase.
Right.
You can set that today as a continuance, at a date and time certain at a regular meeting. It doesn't have to be specifically to 14 days, but by the time you reset it. If they-
When's the closest to 14 days that's a regular meeting?
Now,
2 weeks from our day, we have another meeting.
We have another regular meeting 2 weeks from today.
March 7th is your next regular meeting, and then
Okay.
after that, it would be March 21st.
March 7th, then I propose that they come back with their corrections and
What's the suspension do?
And
no, I'm not proposing any suspension.
Okay,
I'm not proposing any suspension. I'm proposing they fix it. I look at it, if between now, if we don't suspend, and there's a violation, noise violation or anything tomorrow, these people are really, really dumb. That's all I gotta say, is that, I don't see why there has to be a suspension up to, it's 0 to a max of 30 days. I'm saying 0 suspension, but you have 2 weeks to come back to us, which is what one of the owners said they need. And I think the owners of the property are gonna hammer on this. I feel that, so, yes, sir. Am I saying something
No,
I'm not
no, the
supposed to?
thought, counsel, is with this continuance, you do not have to make any action whatsoever. You cannot decide today that
Okay.
what your penalty will be at the time you come back. You can hear additional evidence or additional facts. The staff can give you a report.
That's what-
If 2 weeks is a sufficient time.
That was my
In
thought.
other words, leave that whole section in abeyance
Okay,
until you have the facts necessary to determine number 2.
that's what I was getting at, because somebody said suspension, and I said, yeah, well, we'll determine that in 2 weeks, what we're gonna do, if anything at that point, if we're not satisfied with, or our staff and we don't have any more noise violations or whatever it is that comes to us in 2 weeks, March 7th, to return. That's my motion.
And I think, Mr. Miranda, you already second the motion?
I'll second it
Yeah.
because sooner or later.
But it's,
Yes,
and I-
sooner or later it's gonna end, and it's
Yeah.
sooner than later, 2 weeks
Ms.
instead of
Suarez.
30.
Yeah, and I just want to make sure, because when we're not talking about, we're not making a motion, it sounds like to me, Ms. Capine, and I think that the lawyers would agree, we're not making a motion of a
Continuance.
penalty for the violation.
Right.
I think, and this is, for me, there are 2 choices. One, the choice that you've chosen, to come back in 2 weeks. But I think that maybe as part of the motion, and this is just a suggestion and see what you think, that they cannot have any kind of no sound at all, meaning they can't have any kind of entertainment for the next 2 weekends and come back with the fix so that we know. My point is that I know what he's gonna say, is that we're asking them to do it. Whether or not they do it is up to them, because right now, I would rather us do a finding of a violation of, 14 days without them serving alcohol, which is a much bigger deal than them not having any
Well, this is a
amplified
continuance,
noise.
this is not a.
No, I know that.
So, I would not, you know why I don't wanna do the noise?
Mhm.
Because I wanna know in 2 weeks, do
Yeah.
we have, and I wanna see what happens in 2 weeks.
Yeah, and I agree,
So if
I'm
we
not.
silence them, we're not gonna know,
Well,
till after
I think
that.
we'll know that if they're silent. But I will say this, because I'm really more of along the lines of that we should find the violation and give them the 2 weeks, but I am gonna go with what the council wants to do. And if your motion passes, or if we get enough votes, we'll go forward with that. And I don't have a problem with what your suggestion is. I just think that we have the ultimate hammer now. And I think the only way we can get them into compliance is to use the ultimate hammer.
We have the hammer, we'll have the hammer in 2 weeks, this is gonna
Yeah.
end,
Be a
it's
sledgehammer.
gonna end, yeah,
Yeah.
it's gonna be, if, this is, yeah.
Can I make one suggestion
Of
just for
course.
this conversation? It seems to me you might want to make it a little longer, because what we're trying to judge here is, are they going to comply with not making noise? And 2 weeks, I mean, anybody cannot make noise for 2 weeks.
so-
I want to see a change in
Well, that's-
behavior.
Okay, that's what I'm saying.
Yeah.
But we can't tell them we cannot tell them, I was trying to say that. I was trying to say, let me see on your site plan if you can, and maybe 30 days is better to know. If you're willing to put it in writing, since they were willing to put everything else in writing.
Mr. Chairman, may I? I think it's important to recognize the fact that when you're presented with a site plan, you have the ability to place conditions on the site plan to mitigate adverse impacts. In
Okay.
this case, when you're talking about the speakers and you're talking about the phone, the purpose was not to determine the decor of this venue. It was to address at the time what the council thought would be adverse impacts. So there is a nexus between the noise issues that the community you heard testimony about and the cures that are being proposed. And that were the cures that were placed on the site plan at the time in order to mitigate adverse impacts. So I understand what Mr. Cohen is suggesting that with that nexus, 30 days allows you an opportunity to be able to judge whether or not that
Well, it's gonna
issue is
end in
met.
2 weeks, it's gonna end in 30 days, one way or another, so if you prefer 30 days so that we can see, we can judge what,
I think we need to be able to make a
okay.
judgment of whether
Well,
it's
I'll
working or
accept
not.
that.
That's all.
Anyone else wanna add to, yes, sir?
If I can, counsel, by this continuance, I want to be clear for the record that you are making no representations as to what your suspension period, if any, will be.
Correct.
That's right.
That's still an open question.
Yes, it is an open question.
We're not.
Okay, so I made my motion. What's
We close
next,
the
sir?
hearing, should we open the hearing and continue it then? I believe within the law we should do that.
I believe you did make the motion.
We made the
no,
motion to
wait.
close the hearing, didn't we?
Wait a minute, this is the second part, do we have to do that?
I believe that you can do a motion to continue and then have the hearing reopened in
Okay.
30
Chairman, I
days
move
to
to-
then make a decision on your final,
Okay,
on the
we're
final
making a
motion.
motion to continue and then in 30 days, to continue in 30 days reopen?
Well, no, we gotta open the
Reopen
hearing
for the
now.
limited purpose of the penalty.
Okay.
Let's reopen it here.
Yes, please.
Okay.
Second.
All right, got a motion from Mr. Cohen, seconded by Ms. Maniscalco. All in favor of the motion, say aye.
Aye.
Those opposed. All right, now, the hearing is reopened. Restate your
Now we
motion.
continue, Mr. Chairman. Ms. Capeen, you want to make the motion, so it was your motion.
Yes, I move that we continue to 30 days for the violation corrections.
We're gonna have a specific date on the calendar. Mr. Cohen, do you have that
Okay.
calendar?
And the time
March
again
21?
being? The time again being 10:30? Is time certain?
Time
Not
certain.
necessarily, excuse me, not a time certain, but just a time to be set for the purposes of the.
10:30 on-
10:30
Thank you.
on March 21,
Thank you.
okay? Is that satisfactory, ma'am? I'm gonna make sure we're legal.
Certainly, yes, and
Thank you,
just
sir.
for clarity, for the record, that would be to reopen for the limited purpose of addressing the appropriate penalty.
Correct.
Thank
All
you.
right, we got a motion from Ms. Capeen, seconded by Mr. Miranda. All those in favor of that motion, say aye.
Aye.
Opposed? Okay. We go to item 58.
Done. Thank you.
Barbara Lynch, Land Development Coordination. Barbara Lynch, Land Development Coordination. You want me to wait for them to leave?
Just hold us.
Okay. VAC 1904 is a request by strategic property partners to vacate small slivers of right-of-way in downtown and Channelside area for the SPP replat of Water Street. They are asking for pieces, 2 slivers of Boreen, 1 of Eunice, and some portions of Channelside Drive in relation with the previous vacating of this area, so they could, I guess when they were out working on the plat, they found they needed these small areas to complete the platting of this project. So I went out and took some pictures. Their property's in red, and actually this does not reflect all the vacated area. This is vacated. They've purchased Boreen, and Eunice is vacated. So the yellow areas are what they want to vacate, in addition to what was previously vacated 2 years ago. So we have a picture of, this is Channelside Drive, and everything's under construction out there, so the pictures are sort of limited. And this is near the new USF Medical Center. Here's Channelside Drive on the north side, just east of Nebraska. And Channelside Drive looking west of Nebraska and Boreen Street. So the area is completely under construction at this time. Staff has no objections. There's no easements required. However, we do have one provision. They're supposed to be bringing their plat in for council approval on 3/7, and so the second reading would coincide with the plat. If there's any delay, like to the 3/21 date for the plat, then we were going to have to move the second reading of the vacating to that date. But at this time, we're anticipating that they will be ready to go on 3/7.
Okay, any questions of staff? All right, applicant?
Good afternoon. Scott Gilner with Kimley Horn & Associates. I'm the agent representing Strategic Property Partners. We're only here to answer any questions if you have any, and we concur with Barbara on coinciding the plat with the second reading.
Any emails you want to give us or anything to read?
I'll pass. I sat through it all and I'll pass.
And the city has no plan for expansion of the roadway or anything like that?
No, the plat's going to bring in some new, or realign some of the right-of-ways, basically. So that's already been worked out with transportation.
All right, anyone in the public wish to speak on item number 58?
Move to close.
All right, got a motion from Mr. Miranda, seconded by Mr. Corn. All in favor of that motion, say aye.
Aye.
Opposed? Mr. Corn, would you?
Thank you very much, Mr. Chair. I move an ordinance being presented for first reading consideration, an ordinance vacating, closing, discontinuing, and abandoning right-of-way located northwest of the intersection of Broering Street and Jefferson Street in the city of Tampa, Hillsborough County, Florida, the same being more fully described in Section 1 hereof, subject to certain covenants, conditions, and restrictions more particularly set forth herein, providing an effective date.
All right, got a motion from Mr. Corn, seconded by Mr. Miranda. All in favor of the motion, say aye.
Aye.
Any opposed?
Thank you.
Chair, second reading and adoption will be held on March 21st, 2019 at 9:30 a.m.
All right.
Excuse me, what was second reading? I'm sorry. I think we need 3-7, right? Second reading. 321's going to work for you? Because it has to be done with. Oh, okay, okay. Thank you, that's fine.
Item number 59.
Okay, VAC 1905, Barbara Lynch, Land Development Coordination. VAC 19-05 is a request to vacate an alley, a portion of an alley located generally at 2905 North Ola Street. I have a map for the overhead. This alley is south of Keys, north of Warren, and runs between Ola and Highland. And the applicant is requesting a part of the east-west alley be vacated. We couldn't request that the remainder of the alley be vacated because there are some structures in there, and typically we won't vacate right-of-way where there are structures because it creates a civil problem. And I'll show you the plat. The part that they're asking for is here, and then it runs it bisected by the north-south alley and the remainder of the east-west alley. So these are not landlocked, so this piece could be vacated. So the owner's property is in red, and the portion of the alley to be vacated is in yellow. I have a picture of the property. This is the alley looking east from Ola. This is the petitioner's property. And then this alley is not being vacated. This is north-south alley looking north of Warren, and you see the structure in the alley that stopped us from including this. And the remaining portions of alley are all blocked. And I talked to some of the actual owners who are here today. They may be filing an application for the rest of the alley, but I told him he had to move the shed out. So staff has no objections to this request. There is a request for an easement by Frontier.
Any questions for staff? All right, the applicant.
Hello, Council. My name is Richard Yard. I'm the owner at 2905 Ola. I also live directly across the street at 2908 Ola. The reason we purchased it because it was an abandoned house. There was a lot of traffic going through the alley when it comes to vacant cars and people walking through there and drugs and things of the sort. So we purchased the property and trying to get it cleaned up and get the alley vacated so we can move forward. I do have a friend of mine here, Justin, who is willing to speak on behalf as well. He lives in the neighborhood as well. And is there any questions that you guys would have for me?
No.
Thank you.
You said you wanted to speak.
Okay. I didn't know if there was a part for public comment. Justin Rickey, 103 East 26th Avenue, Tampa, Florida. The current president of the Tampa Heights Civic Association. My land use committee has reviewed this petition. They found no reason to have any issue with it. I can say that Mr. Yard has made significant improvements to this property, not only just this property, but surrounding properties. increasing the value and the quality of life of his fellow neighbors. I really appreciate everything that he's done in this area. It's definitely made a big difference. The house that he's made the renovations to is night and day, really, it is. We had a lot of problems with prostitution, drugs, homeless encampments on the property. We don't have those problems anymore. So I would just urge you to please approve the petitioner's request. Thank you.
All right, anybody in the public wish to speak on item number 59?
Move to close.
Second.
All right, got a motion from Mr. Miranda, seconded by Mr. Corner. All in favor of that motion, say aye.
Aye.
Those opposed? Mr. Maniscalco, item number 59.
Thank you very much, Mr. Chairman. I have an ordinance vacating, closing, discontinuing, and abandoning a right-of-way alleyway located south of Keys Avenue, north of Warren Avenue, east of Olive Avenue, and west of Highland Avenue in Warren and Keys subdivision. A subdivision in the city of Tampa, Hillsborough County, Florida, the same being more fully described in section 1 hereof, subject to certain easement, reservation, covenants, conditions, and restrictions, more particularly set forth herein, providing an effective date.
All right, got a motion from Mr. Maniscalco, seconded by Mr. Miranda. All in favor of the motion, say aye. Aye. Opposed? Okay.
Second reading and adoption will be held on March 21st, 2019 at 9:30 a.m.
Okay. All right, go to item number 60.
Good afternoon again, Council. Kristen Mora, Legal Department. As an initial matter, I will bring up that there was a continuance request by a third party on this application. If Council would like to hear the continuance request, as well as the applicant's thought before we proceed with the hearing, it's up to you.
Number 60?
Yeah, I thought 60.
Chairman of City Council, my name is Scott Steady with Burr and Foreman. I represent the applicant petitioner, and we would like to proceed. I mean, basically, this house is finished, it's ready to be occupied shortly, and we'd like to proceed. And we think it's a pretty straightforward matter, so.
Oh, third party, okay.
All right.
Well,
This was
and it's not clear to me that actually by the way, at the same time, I would say, because I'm trying to be cooperative, but at the same time, we're the applicant. I don't know if simply a person that's of notice the city council can entertain a request, but I don't think it's necessarily a good precedent. I don't really think they have standing, by the way. So I don't want to give too short a shrift to this. I mean, we would like to proceed. We noticed it, and we're ready to go.
Okay.
Julie Mandel, law firm of Gray Robinson. I am representing a third party who lives behind the property, who, as I stated in the letter, could not be here today. And I do agree with Mr. Steady. It's not as a matter of right. I did want to make it part of the record, just in case that was something the council wanted to consider or the applicant wanted to consider. I am prepared to proceed forward with the understanding that my client could not be here today, and his testimony that was previously placed in the record will need to be brought forward into this record. Thank you.
All right, staff.
Are we ready to proceed? Do you want to say anything?
Council, I didn't hear a motion to continue, so I assume that council would like for me to proceed.
Can we get a motion to continue?
I will proceed. Again, for the record, Kristen Mora, Legal Department. This is for property at 2620 and a half North Dundee Street. This was a variance. This went in front of the Variance Review Board, and it was to increase the height of events in the front yard from 6 feet to reduce the front yard setback from 20 feet to 8 feet, and with the allowed encroachment for eaves and gutters. The Variance Review Board denied this request unanimously, 5-0. Stating that the hardship criteria had not been met. As you are familiar, the criteria before you today for the decision, this is a de novo hearing, and you have the ability to hear this under, and the criteria that you will apply are the criteria found in section 2780 of our code. The potential motions of City Council, which are stated on the handout that I provided you, are to affirm the board's decision, which would be to uphold the denial, to overturn the board decision and approve the variance, And you may also add conditions at that time, or you could remand the board if you feel that there's further work that needs to be done by the variance review board. Mr. Eric Cotton will provide some of the information and background on this request. Thank you.
And if I can, Mr. Chairman, if council would please receive and file any documents that need to be filed before the hearing progresses.
So moved. Second.
I got a motion from Ms. Red, second from Cohen. All in favor of the motion, say aye.
Aye.
Opposed?
And again, if there are any ex parte communications, please do disclose them at this time. Seeing none, I thank you very much.
Good afternoon, Eric Cotland, Development Coordination. As Ms. Moore was just summarizing, this went before the Variance Review Board in November, and the board denied the request. The property is at the corner of Bryan and Dundee. It was subject to a formal decision, FDN 1787, to split the lot in half. This is a site plan from the variance, but it was parcel A and parcel B. As part of the condition of the approval, the zoning administrator made the determination that this would be a continuous frontage along parcel B. And once that was done, the applicant was not able to put a pool in the rear yard without taking a variance. As a single front, they'd have to reduce the front yard from 25 down to, the staff report says 2, I think Kristen said 8, so I'm not exactly sure what the request was. Sorry about that. But it would be tied to the site plan, and to increase the height of the fence in the front yard from 3 feet to 6 feet. I have photos, but I believe the applicant has newer photos than the ones from November for the VRB. I'm here to answer any questions regarding the code if you have any for me.
Any questions for staff?
The Variance Review Board approved this?
No, sir, they denied it.
Denied it.
Yes, sir.
Thank you.
The applicant?
Yes, thank you. Chair, Member City Council, again, Scott Steady with Burr Foreman, representing the petitioner, but also the builder is TB Homes. And I have both Eric and Blair Franson here if they have any questions of them. I also have some handouts if I could provide. The DVD is in the record. It is in the record, yes. So, okay, appreciate it. I know it's been a long day. You just give us a little time. Appreciate it. Why we're here again, as staff mentioned, this was one home on this property. There's now 2 lots there. There's no question about that. We sought a previous builder back in 2017 sought a determination by the zoning administrator to be able to split these lots. TB Homes later came in and is building both homes. There's a home existing now on the other lot, and there's a home that I'll show you is almost completed on the lot that we're talking about today. But in determining that the lot split, and by the way, both lots fully comply with the zoning RS 75, and as far as square footage, as far as setbacks, everything they comply. So there's like 2 fully complying RS 75 zoning lots. But as the staff mentioned, the zoning administrator, when they looked at this, said historically this property is like a prow of a ship. And that prow, they determined, was all going to have a front yard, which means a 25-foot setback. The rear, what looks to be the rear, is considered a side yard, so that's 7 feet. So you have 25 feet wrapping the property and a 77-foot setback between this house and the house that they recently built. I submitted into the record when we filed this petition the argument of a hardship, which is the hardship is this complies with RS 75. It's a fully compliant lot, but at the same time, because of the zoning administrator's determination, the true backyard is not a zoning backyard. And one more point, when the city gave an address for this property, they gave an address on Dundee Street. So the house has to orient towards Dundee. The back of the street is, the back of the house, the natural back of the house is on Bryant Circle. So the house is oriented towards Dundee, and the back of the house is oriented toward Bryant Circle. And I see you look at some of the pictures, and I'll show them to you now. So here's the home. It's it's almost completed. And here's what is practically the backyard. There's a porch here. They call it a lanai. I call it a porch. There's a steps leading down to what will be the backyard. This is what we're proposing, and we are proposing and we put in the record that this would how a 6-foot fence would look. We're proposing 12-foot palm trees pursuant to a site plan we're submitting, 12 foot along the back here, 6 feet just over the fence here for the rest of the property. And then
Excuse me,
here,
sir. Excuse
yes,
me.
sir.
Just been informed that they don't have your DVD.
We submitted it with the file. We absolutely did.
The application.
Well, here's the application. I can't.
What is this?
Well, I believe you submitted it with the application. This is my copy.
Oh, that's your copy.
Yeah.
No, I just wanted to inform you that
With the staff that looked at this before.
Rebecca Kurt, Legal Department. Sorry to jump in the middle of the hearing, but you can
Submit.
turn in the DVD during the hearing.
Turn it in right now.
that's what I was going to suggest. That's what I was going to suggest to you. As long as you can.
That's okay. A little bit of almost a heart attack there. But not quite. Thanks, Martin. All right, so the DVD is in the possession of the staff. Great. All right, so here's the what we're proposing for a site plan. As you can see, like I said, it's kind of like a prow of a ship. It goes around as a full 20-foot setback. So right now, what we're looking for is a variance to allow, instead of a 3-foot fence that would be allowed in a front yard, to go to 6 feet, to provide basically a buffer for the abutting property owner, and provide the family that will live here some ability to have some privacy to play in their backyard with the kids, obviously. So here's the pool that's being proposed. Here's the 12-foot palm trees that would go here. There's a key down here, and then the 6-foot palms. Really, from our perspective, this is a pretty straightforward request. There's going to be a family here located pretty soon after this. We proceed with this. Probably have a couple little kids. They're going to go out there and play. This is going to be their backyard. We're basically asking for, like everyone wants in Florida, have a small, reasonable pool in their backyard. We did, just as a couple comments, the house that was here before, there was one house that had a very large pool cage. There was some discussion at the Variance Review Board about a pool cage. There will be no pool cage. This will be out in the open. There's about 5 homes, by the way, in Sunset Park. There's also orientated houses. There's a number of pools on the side yards, so this is not necessarily unique to the neighborhood. And unless there's any questions. What came up, one last comment, what came up at the Variance Review Board was, and I did not conduct that, but when I reviewed the record, a lot of it was discussion about the split of this lot. But the fact is, this lot fits the zoning requirement, and it was a good land use decision. So unless there's any questions, I appreciate it.
All right, any questions from council?
Julie Mandel, the law firm of Gray Robinson, and I'm here on behalf of Mr. and Mrs. Jeffrey Paskard, who live directly behind the property and have been involved in this process through the Variance Review Board and did submit evidence and testimony at the Variance Review Board. As I said, they could not be here. They had a pre-planned trip. So all the evidence that's on the DVD would be considered evidence for you to consider as part of this hearing. That being said, it is a de novo review, and I wanted to raise a few issues with you, and I know I have a very limited amount of time. I think it's incredibly important in looking at whether or not this is a self-created hardship, because that's really the criteria that the VRB based it upon, as well as what we are asking you to look at. I first want to point you out to you, and this is the second page of the formal decision under which Ms. Moretta, in her capacity as zoning administrator, agreed to provide that the lot met the criteria for the purposes of splitting the lot. However, she makes 2 notes in this, and I think they're both important. The second one is, number 9, is relating to the idea that both North Dundee and South Bryant Circle are intended to be treated as front yards for the purposes of orienting the house and is for the purposes of constructing the house and any parts of the house, such as a pool or those kinds of things. So that was inherent in the approval. The second, and I think this is just as important, because the why, one of the reasons why that would have been part of her consideration is note number 8. Sunset Park subdivision dedicated a 30-foot front building setback. While the city does not enforce deed restrictions, you need to be aware that this restriction exists. And there's some background as to why that particular provision is within this approval. That being said, per plat, not just per City of Tampa code, but per plat, this was always intended to be treated as front yard. It was not intended to have any buildings as part of that front yard area, and that is something over and beyond what was in the city code. Now, I will say to you, this is not something the city has the right to enforce. That being said, the property owner was well aware of these conditions, and here is where the self-created hardship unfortunately comes into place. When this particular developer went to go ahead and develop this property, they did not ask for this variance prior to construction of their house. They went ahead and did the construction in such a way that it literally is within, I mean, perfectly within this 30-foot building envelope, which exists right here. And so the house fits perfectly in there. And that is almost completed. And it's at that point in time that they have moved forward with this variance request, which would put not just the 6-foot fence, but a pool within that 30-foot building setback line. And also within the 25 feet that the city requires. I can't say why they did it this way. Certainly they had the right to do it this way, but it certainly puts my clients in the position of having no ability to have any say as to what may or may not happen because they've already constructed the house. Not to mention the fact that there's no opportunities to move the house, to move this around, to maybe create more of a buffer. So unfortunately, that is, in my opinion, the definition of a self-created hardship. Not only did they move forward with an approval, which was very clear on its face, they moved forward with construction and then came back after the fact to make this condition apparent. And I totally understand that, in fact, in this area, having a pool, having the back fence is important, and it is part of that area, part of that living room, or that area of Sunset Park. That being said, they built the house and then came and asked for the pool, and I think that in and of itself was the self-created hardship that forced them to push their pool and their fence as far back to the street as possible. Not only that it intercedes within the setback of the city, but is also wholly and completely within the building setback. Therefore, we would ask for you to uphold the decision of the VRB. I can answer any questions. Thank you.
If I could quickly ask a question of Ms. Mandel. Now, in the packet that Mr.
Excuse me.
God bless you, or you're coughing, but God bless you anyway. Mr. Steady's packet included the Harringtons, I guess, are, and I want to know where your client is in relation to the Harringtons, because the Harringtons are at 26, I think it's 2620, and they're at 2620.5, according to what Mr. Steady's got in there. So where is your client located at?
I provided you a packet prior to this hearing, not sure if it was going to be moved forward or not.
All right, that'll be fine.
Which has that information. It's a little bit off, but this is my client's property right here.
Okay,
so they literally, and I provided some pictures that show this is their front yard looking at the backyard of the property as it's being constructed. So they really are very directly affected.
Yeah, no, I understand. I'm just saying, I wasn't sure because of the way that the shape of the property was. I wasn't sure if there were two properties behind there, and that was, your client was in one of those properties. That's why I was asking.
Thank you.
Thank you. And Mr. Steady, real quick, I want to make sure the Harringtons are in that other place that's being under construction now, according to her?
Yes.
Okay, that's it.
And I thank you. I mean, matter of fact, they are the most affected right there, but they also just recently bought their house.
Yeah, I read it, so I thought, I wasn't sure where she was at.
Right, and for full disclosure, here is Julia's client's house. It's right across. We're not debating that, and we totally understand it. So just a couple comments. First, when you say self-created hardship, I mean, I will point out that Julia's client also had, when they moved in 1990, there was one house on the lots. Early 2000, they built their house, sold the house next door. They had every right to do that, every right to do that. But they increased the density by 2 homes in the neighborhood. We had actually, the previous developer, builder, had every right to ask for this lot split. It complies with RS 75. The issue, and I don't deny it, is this front yard that totally envelops the property. We didn't create a self-hardship. That is the hardship that no one else has. It's a complying lot that you don't have a backyard, basically. So, and what will happen here is, what's the reality? There's going to be a 6-foot fence rather than a 3-foot fence and a pool. So there's going to be a pool, but in the end, this is going to be their backyard. This is where they're going to have barbecues. This is where they're going to have family functions. Yes, there's a builder here, but at some point, there's going to be a family there. And I think it's fair to look at that family that will live there and say, what harm is it to have a 6-foot fence rather than a 3-foot fence, a reasonable pool in what is basically their backyard? So, you know, and by the way, when Julia pointed out, you're right, the house was built within the footprint that they could build it in. They had to build it in there. But the enforcement of that 30-foot would not apply to the pool. So again, if you approve this, I think in the end, is it really going to affect the property owner that's across the street looking at a 6-foot fence rather than a 3-foot fence? And we would commit, and if you approve this, which we'd appreciate, to put in approval of the site plan we submitted, committing us to put those palm trees in. We certainly want to follow up with that commitment. We appreciate your consideration.
Sir? Yes. I came out because I looked at the lot, and this is exactly the lot that I had in Beach Park. That's not that lot, but one side was Azeel, the other side was Royal Palm Way, and the other side was West Shore. And I was told by the city that I had no backyard, and I could not put up a 6-foot fence. So I put up 8-foot hedges around the entire property. That I could do, landscaping. When I see this, I understand the dilemma. I understand it because I went through it. It was exactly that configuration. If you could see it there, the house that we built is there now. And I understand. So what you're arguing is that that is their backyard.
That is their back. That is effectively that their front yard is on the other street. On this side, there is a back. This is going to be their functioning backyard.
They're
It's the only
functioning. Well, yeah, because they built the house the way they built it.
Well, they built the house on the road that the city gave the address for. So
Okay,
they
which
built
is
it on
Dundee.
Dundee.
Right.
And then the backyard is on the circle, on,
Right.
what is it? It's on the other side.
My house was on Royal Palm and my backyard was Azeel.
And by the way, so there's actually no defined backyard pursuant to zoning. The
I'm
side
sorry,
yard
there's
is,
what?
under the zoning, under the approval, the front yard is the prow of the ship, like I said.
Yeah.
The side yard is the 7-foot between this house and that house.
Correct.
There's no zoning backyard on this property.
Right.
Right.
I
So,
know.
so that's
I
why.
know very well.
Right, that's why we need the variance to allow this backyard that's there, that's going to be a backyard, to function as a backyard.
Yeah, I went through that with the city, so, yeah, I understand.
Please, thank you.
All right, anyone in the public wish to speak on item number 60? Anyone in the public wish to speak on item number 60? All right.
Move to close?
Yeah.
We're gonna rebuttal?
Rebuttal.
They just did it.
No, okay, move to close.
All right, we got a motion from Mr. Miranda, second by Mr. Maniscalco. All in favor of the motion, say aye.
Aye.
Opposed? What is the pleasure of the council?
Let's see. Wait, let me see what I've got here. Okay, I need my paperwork.
They didn't give us a sheet today.
Oh, there was a sheet from earlier. I'm trying to find it. Yeah, I got number 57. I don't have number 60.
Here, you take one.
Councilman, I direct your attention to item 9 on that page, the first page.
My motion is gonna, may I make a motion?
Yeah.
Okay. My motion is to overturn the board decision and approve the variance.
Second.
Maybe added, no, I'm not gonna add any conditions, that's it.
Is there anything else? Okay. Yes, sir.
That's it?
That's, I made the
Yeah,
motion.
using the criteria in section 27.
If I could, under section 27-80, under
80, applicant.
A1, the alleged hardship or practical difficulties are unique and singular with respect to the property or with respect to the structure or building thereon. So it's really about the property.
Right. Thank you.
You're welcome, ma'am.
Yes, section 2780 and section 1 of 2780. Okay?
All right, got a motion from Mr. Capeen, seconded by Mr. Maniscalco. All in favor of that motion, say aye.
Aye.
All opposed? Okay.
Motion carried, recording voting no.
All right, 6-1, you need a motion to reset the public hearing?
Item 61, reschedule the hearing to April the 18th at 10:30 in the morning.
Second.
All right, got a motion from Mr. Randy, seconded by Mr. Suarez. All in favor of the motion, say aye.
Aye.
Opposed? All right, 62.
62, move to reschedule 62, Mr. Chairman, to continue through March the 21st, 2019,
62?
10:30 a.m.
Before you accept that motion, did you go on number 62 now?
I'm sorry, I didn't realize we were on 62. Rebecca Hurt, Legal Department. I'm here for item 62. The property owner had previously requested a continuance on this item. It is not a de novo hearing, and yesterday he withdrew his request to continuance based upon the fact that the other party did not file any exceptions or requests for oral argument. I do have some sample motions for you, and I'd like to just run through the process and explain to you where we are.
My goodness.
We're so efficient. We're going to squeeze every sentence out of it.
Thank you. Again, Rebecca Kurt, Legal Department. The underlying decision on this was a request for a design exception that was a design exception 2, so it was noticed to the neighbors, to allow stairs to encroach into the front yard setback from 25 feet to 20.4 feet. That was approved by the zoning administrator. Since it was noticed, the neighbor had the opportunity to challenge that. As you know, because you hear these all the time, a design exception typically goes to you for de novo hearing. The neighbor chose to go to the hearing officer and have the de novo hearing in front of the hearing officer. So this is not a de novo hearing. You have the recommended order from the hearing officer to base your final decision on. The hearing officer in this case recommended that City Council uphold the zoning administrator's approval of the design exception. I do want to tell you that the neighbor was here this morning, and I spoke with her, and she told me that she did not file for oral argument or exceptions because she did not feel she got her information in time. What I told her is what I was going to tell you, because I don't provide people legal advice, but I told her my advice to City Council was that objection needed to be made before the deadline to file for the exception in the oral argument. It couldn't be raised at this late date. She left. I told her she did not have to leave. She told me she understood that and was not leaving and would not tell anyone that I told her to leave. But she is not here. And I think she would agree with that. We had, I think, a clear understanding of that. That being said, again, this is not a de novo hearing. City Council has the ability to open it up only on a limited basis under the code if you find an ambiguity in the record. So where we are is we had an approval by the zoning administrator. You have a recommended order that you uphold that approval for the design exception. There were no exceptions and no request for oral argument filed. And at this point, it is City Council could open up if you find an ambiguity in the record that was before you, or you can uphold the recommended order and make it a final order, or you can remand it back and make specific findings based upon that, which is in the motions that I gave you, or you can substitute a conclusion of law.
I'd like to make a motion to adopt the recommended order as the final order.
Second.
Got a motion from Mr. Corner, second by Mr. Maniscalco. Any discussion on the motion? Okay, hearing none, all in favor of the motion, say aye.
Aye.
Opposed? Okay. That's it. All right. 64, item 64.
Good afternoon, Council. Tom Snelling, Planning and Development. Here for item number 64. It was about the skateboard structure and whether or not, what kind of city codes we could use to regulate such items. The City of Tampa, we consider, when we're reviewing, that's correct, right? Subject to existing and permitting process. You got right now, the City of Tampa has reviewed and approved a couple of other skateboard-type ramps and things like that in the City of Tampa. So we already have a process in place that reviews these things and passes judgment on them. This one here is, both of them are ironically in Seminole Heights. And what I have to show you here is the initial thing that this person did. They went through the permitting process. They had to come in and get first they got a design exception. I put this up here simply because they were a subject in the greater Seminole Heights areas, and is to reduce the required setback from an accessory, which is important to understand, is that we consider these as accessories. We don't consider them playground equipment like a swing set or a slide. A pool is an accessory structure, for example. We treat them the same way with review. Having said that, this person, Mr. Clemens, went through, got the design exception, and then he went in and he built one heck. And I just show you this, all the shaded areas is his ramps. He kind of wound them all over the place, and now he's coming back in to expand on that. Again, he went through all the zoning compliance, floodplain requirements, wind load factors, everything that he had to do in the zoning code, he did that. Now, so what I'm saying is that this person that has this skate ramp, what I also have to show you, this one here, which you've seen this, you got the PowerPoint of this particular one, and since then, code enforcement has gone out, cited them on on February 7th for the accessory structure does not meet the required setbacks from the side yard of the rear property line. Okay, that was the first citation.
Can I just stop for a second, Chair? Okay, so the first drawing that you showed, is that the same person that built this other?
No, that was the person that went through the legal process.
Okay, all right. I just wanted to make sure that we were straight. Okay, that's it. I just want to know.
Okay, and then the very next day he went back out again. Oh, sorry. The very next day he went back out again, and he was cited for building without permits. In essence, the setback issues could be taken care of very simply, but him building without permits triggers a whole complete code review. And the types of things that they will have to do to turn in when they turn in their site plans, they're scheduled to go in front of the hearing magistrate. The magistrate will make the decision. These are fairly clear, but the zoning questions that he has to deal with in terms of the designs for the permits he puts in, if he chooses to turn in the permits, he gets a double fee for not turning in permits in the first place. These are the questions, the property line, the height, the square footage, the impervious area. We would consider this, and I've consulted, this design creates impervious area, which will affect the drainage patterns, they will be required to show how their drainage is being taken care of, and et cetera. Might have to put in a swale, they might have to do something else. The other thing which is interesting, especially in the building code, it's the materials and fall protection, which he does not have. He has this railing here and here. He also is required to have it on both ends. Anytime you build anything above 30 inches, you have to put fall protection in. I just built my house. It was at 35 inches. They made me put in a rail on my porch. The other thing I want to show you, then the flood zone, we already talked about that. He's got to turn in siled and sealed drawings because it has structural engineering kinds of questions. Wind load, strength load, is it hurricane tied down? And in this sense, I'm going to say, I'm guessing maybe not, because these here, those are bricks and it just kind of sits on there by its own weight. There are code requirements that require you to tie down your structures. You're supposed to tie down trailers, you're supposed to tie down accessory tool sheds. If they're over 150 square feet, you have to make them secure from hurricanes. So there's quite, there's several code issues they're going to have to comply with and go through that review. After he goes to the hearing magistrate, then he comes back. Like I say, we have processes, code review, zoning review in place to address these kinds of things. In this case, this person just chose to not do any of that. What a surprise to you that somebody did something without getting permits. Being in Seminole Heights, one of the questions is that an accessory structure is allowed to be up to 950 square feet. It's impossible for us to take any kind of specific legal stance on how big that thing is until he turns in his plans. If he turns in his plans and he says it's 960 square feet, it has to meet principal structure setbacks, which is a big push away from the 3-foot, 3-foot. If he says it's not, it's 900 square feet, and then we do it, we review it, they'll approve that. But then when my building inspectors go out there, they'll go out there, they'll get out the tape measure, they'll look at it, and they'll make determination exactly how big it is. Does he have the tie-down straps? So, unfortunately, or fortunately, we do have a process, a building and zoning process in place that addresses these very types of structures. Unfortunately, we've never had a chance to opine on whether this thing could be built, how it could be built, where it needed to be located, and on and on and on, because he did not come in. As a result, he ended up getting a code violation. Now he's going to go to the hearing magistrate. That's in this case. The larger picture is, and it's good news from my perspective, is that we have a process in place. We have 3 skateboards that are currently kind of under review. One's being expanded. And the one that I shared with you, Councilman Suarez, that was one of those 3, just to give you a sense of that, people actually do follow the code. I'll answer any questions you may have.
Meanwhile, in the one that you showed me, that's right up to the fence,
Yes,
you
sir.
have the neighbor that has I know they have a violation with code and whatnot because they didn't pull any permits, they didn't do anything. But the neighbor right behind there has to listen to these individuals on skateboards.
Yes,
Not
sir.
only that, they sit on the fence. Not only that, when they reach the top, they stand up so high that they can look right over into the neighbor's yard, right into their pool, or if they're sitting outside eating dinner, whatever it is. I mean, it's right up to the fence. What kind of relief does the adjoining homeowner get in the meantime?
Well, in the meantime, I know he has been in touch with TPD about the noise, and TPD, I talked to Mr. Hatch and his wife, and TPD's been very responsive to that in terms of the noise things. And I understand about the height and that being above that. See, this looks to be 6 feet. If that's a fence, a 6-foot fence, maybe it's a little bit bigger. This is pretty tall. So the height of that thing is going to dictate where it has to be located. His only relief will be as if it is so big, and like I say, I don't know how big it actually is in square footage, but if it's above what you're allowed there, it has to meet the principal structure setbacks and would have to be moved. The other option, he could tear it down and be in complete compliance, but frankly, I don't think the gentleman who owns the skate ramp is going to do that. The relief that he has, Councilman, you continue to call TPD, and TPD comes out, and after they build up a certain amount of times with citations and all that, then there starts to get additional increasing penalties. I'm not completely familiar with how the zoning or the excuse me, the noise ordinance works in that regard, but I know that there are escalating circumstances, and that's why I did encourage them to continue to call, and they said that they would, and the police said, according to Mr. and Mrs. Hatch, that they've been responsive to that. In terms of somebody sitting on your fence, that's trespassing.
And I know there's photographic proof because they showed it to us last
Yeah,
time.
no, I have the PowerPoint, I downloaded that, I didn't use that because.
But beyond that, the violation that you showed opened, what, February 7th, and I think it says to come into compliance by the 26th, so Tuesday.
Well, what they'll do is they'll go back out and look,
Uh-huh.
and I'm betting dollars to donuts that they're gonna still see this park there with everything there, and they may see people sitting on the fence as well, but then they'll say he failed, then they'll go to the hearing magistrate. One of my staff members working with code enforcement will explain exactly what they saw, that they were still in violation. The magistrate will hear that case, and then he will issue, or he or she will issue their ruling on what he needs to do. He could start to fine them, she could start a daily fine, to start running, so many, hundreds, up to $1,000, I think you can actually assess, running on the lien, which he would have to take care of, or that would continue to run until and when and if he would come into compliance. But once he has that lien and that fine on there, the magistrate and code enforcement could require him to pay that fine.
All right.
But there, the big picture, we have processes in place, and it's unfortunate there are some scofflaws out there that do what they do. We chase after a lot of them.
Mr. Cohen?
Nope.
Okay. All right, anyone else?
This is Mr. Hatch.
Okay.
I'd first like to say thank you to this council for expediting this issue. Everybody in the city of Tampa has been great. They've all been very responsive, so I really offer my sincere appreciation for that. Especially the police department, who have better things to do than deal with noise and privacy issues generated from half-pipe structures. The city of Tampa has a minimum of 3 skate parks, to the best of my knowledge. Proudly spent millions in making that happen. And I'm sure one of the many reasons that the city of Tampa built these skate parks is to avoid any residential conflicts that these structures are notorious for. I forgot I had them in my head. Yet what the city of Tampa failed to do was develop specific ordinances to define residential skating and half-pipe structures to prevent situations like this before us today. These structures are becoming mainstream, and more will be built. I have no issue with skating or BMXing or any X Games, nor do I have any issue with the person's individual right to do the things that they enjoy in their own backyard. However, I do have a problem with any activity or structure that violates adjacent properties' ability to peace, quiet, and privacy, as well as a structure which has a negative impact on the marketability of the adjacent properties. Just to kind of reiterate, as a result of this structure, I've lost all my privacy in the first floor of my home, with exception to my bathroom and a front office. My backyard has an 8-foot high fence. I had 100% privacy before. I have no privacy in my backyard. And by the way, this isn't kids on this. This is adults on this structure. I have measured decibel readings as 115 decibels at my property line. I can hear it inside my home. And no one in their right mind, if I had to sell my house, would want to buy my house. My neighbor that built the structure has been cited. He's also made it clear that he's going to simply move it 3 feet back. Still, with the same wooden material, with unenclosed ends amplifying the sound, still with no insulation to help absorb the sound, no sound dampening materials whatsoever, still with hollow pipes to make grinding louder, still with an embossed membrane, which intensifies the sound, still with pull coping, which intensifies the vibration, And yes, still being able to violate my privacy even 3 feet back from my property line and detracting the markability of my home. Simple ordinances or items that can protect my privacy. There's so many simple things that can be done to help protect the privacy and noise. Only allowing concrete construction. The first skating structure that was shown before.
That means your time is up.
Can I, one more minute, sir?
Go ahead.
Thank you. Simple ordinances, minimum setback feet, occupied residence of 100 feet or even 50 feet. This is 25 feet from my home, which is the distance from that wall to that wall, from my back door. I have a very small backyard. Furthermore, should the city develop these ordinances to address these structures, I know that they cannot make them retroactive to affect my situation. So I asked today from the city, and this can be done in a short amount of time, is to put a stay on the issuance of any permits for half-pipe or skating structures and any other name item that these items may fall under, until they can develop equitable ordinances for all the citizens of Tampa. Thank you for your time.
Thank you.
Any
All right,
questions?
any questions for this gentleman?
I was going to ask a question of Mr. Snelling, just real quick. In terms of the violation, I know that you went through the whole process. Have they found that this facility is being used as a business in any way?
That I don't know, sir.
Okay.
But that's a good question.
Well, I mean, I think that it's probably worth investigation. I think Mr. Hatch just mentioned that, it's not children that are using it.
No, and it shows up on Facebook and social media and probably other friends.
Yeah.
Other skaters.
Right.
Come there, and there's probably I don't know this, whether he's charging any kind of consideration or any kind of fee to do that, I have no idea.
I'm always suspicious when somebody puts that much money and effort into putting something in their backyard, and, that is not a cheap, thing to put up. The kind of boards you have to put up there, all that other stuff, it's not an inexpensive thing, especially people using it quite a bit. So just curiosity, because, that might be a violation also. I don't know.
Okay.
Okay.
Good.
Yeah.
I think clearly it's a violation of noise. Sure.
And it is. TPD, as Mr. Hatch said, TPD has been out there.
You just had one of noise now. It'll amplify music. This is not amplified, but it's still noise.
Ms. Kurt, can I just ask you, the suggestion that was made to us about putting a stay on the issuing of new permits, is that something that is within our purview to do?
The city
A
council,
moratorium.
the state statute does not allow emergency ordinances, even for purposes of stay, that affect uses allowed in the land development code. Your own code requires that those go through your typical cycle.
With the planning commission?
With the planning commission, so we can't do that. The short answer is no, you can't do that quickly.
Thank you.
You could do that in the same time frame as you could do any other regulation.
Okay. All right, anything else, Ms. Snelling? Anything else from you? From you?
Oh, no, sir, no, thank you.
Okay.
That's complete, I'll just do any other questions you might have.
All right, well, thank you.
Okay, thank you, council.
Go to item number 66.
Hello, Rachel Peterkin with the Legal Department. I'm here on item number 66, which is to present a draft ordinance regarding diaper changing facilities in men's and women's restrooms in the city of Tampa. I have a copy of the draft ordinance that I provided to you earlier. I also have copies of State Senate Bill 1082, which was filed very recently in the state legislature for the session that starts March 5th. It would incorporate some baby changing table requirements into the Florida Building Code. It has a companion bill, which is identical, which is why I only gave you one bill, that was filed in the House. That's House Bill 927. I have language within the draft ordinance that I provided to you that would address any preemption or building code changes. So as you know, we can't know what that bill will look like in the state legislature. It may not go very far. It may be changed radically if it does proceed. So it would be appropriate for you if you decided at this time to wait to see what happens to that legislation as it moves through the legislature. But it would also be appropriate for you to decide to take action here in the city for buildings that we own.
Mr. Chair, if I may. Thank you, Mr. Chair. Yeah, I think it's good to move forward on this. I think it makes sense. This is something that the city of Tampa can take a stand on this very, very important moral issue. I'm drawn to it for a number of reasons. First, myself, I'm a father, and I think that many of us who raise children who are men have had the experience of going to a restroom, a bathroom, and trying to change your child when they're, an infant or 1-year-old or what have you, and having nothing there. I remember that happening to me, and that's why I was drawn to this. This is a very good statement on fatherhood, that fathers matter and fathers have to be a part of their sons and daughters' lives. I think that's a positive statement for the city to make. And then secondly, frankly, it's offensive. It's very, very offensive to have changing stations just in women's restrooms. And not in men's restrooms. That's a sentiment that we allegedly left behind as a society 40, 50 years ago, and yet it's still here. So I think this is something that we should move forward with. The legislature may very well move forward with their own version of it. I certainly hope they do. I think the more the better, but I think that this is a good ordinance-based stance of moral solidarity that City of Tampa can make, and it's a good statement, so I'm certainly supportive of it. And I thank you for your work.
I second Mr. Vieira's motion, and hopefully he can put it off the first reading in a couple of weeks.
If I could just make one question real quick, and thank you, Mr. Vieira, for bringing this up. And I was looking at Senator Book's legislation. It looks like, as you mentioned, it jives pretty well with it. It doesn't look like it specifies anything about public buildings per se and ours, and it just deals with our particular facilities. Is that correct, or am I wrong?
The state legislature's version.
Not the state legislature, I mean our version.
Okay, our version just deals with city-owned buildings.
Okay. And then the rest will expand it if that Senate bill and its companion in the House gets passed?
It would be a change to the Florida Building Code, so it would impact all buildings, both
Yeah,
city
because I can see that the
buildings
language,
and
you jibe perfectly with the language, which is good. And I will tell you, having 3 sons and my youngest now is 17 years old. There were times that there were no changing tables anywhere, not even in some of the women's bathrooms and public facilities. So it's a good idea, and it's definitely something that will be helpful for people that are bringing children into this world. Thank you.
And if I was just going to suggest that you make a motion to put it on first reading at March 7th, if you'd like.
Yes, sir. I will take the advice of my wise colleague and motion to have this move for first reading on March 7th, if I may.
All right, got a motion from Mr. Vieira, seconded by Mr. Miranda. Any further discussion on the motion? All those in favor of the motion say aye.
Aye.
Opposed? All right.
I hope it's not a reflection of any expectations from you.
Oh, no. Not at all. Good point.
All right, go to information reports. Mr. Vieira.
None. I wanted to just make a note that it appears that on the commendation for HCC, I was supposed to wait for Councilman Reddick for that, and I apologize, Mr. Chair, for that. So accept my public apology, sir.
Thank you.
Thank you, sir.
Mr. Miranda.
No, sir.
Mr. King.
None, sir.
Mr. Maniscalco.
Just one item. I'd like to make a motion that on April 4th, that we allow 10 minutes at the beginning during ceremonial activities. There's a group, there's no official name, of students from Sicily that's organized by Vince Pardo and other people. And he had asked that they be given an opportunity just to introduce themselves and say hello, just to see how City Council is on that morning.
And they're from Sicily?
Yeah.
Oh, great.
Yeah, like exchange student kind of thing.
Okay.
What's the date?
April 4th at 9 a.m. ceremonial activities.
All right, got a motion from Mr. Maniscalco, a second by Mr. Vieira. All those in favor of the motion say aye.
Aye.
Opposed? Okay, Ms. Corner.
Yeah, just one item, Mr. Chair. There was some discussion this morning related to the planned repaving of Beta Bay. and I happened to be out of the room when the motion was made related to sending a letter to the mayor. I wanted to suggest that Ms. Duncan come to City Council for a staff report on March 7th and give us an update on actually what the status of the project is, what the proposed scope of the project is, and clear up. There's an awful lot of confusion in the community about what actually is happening, given the county commission's deliberations on this yesterday. I'm not exactly sure where they ended up. I want to ask that Ms. Duncan come back on the 7th under staff reports, because since that's only 2 weeks, that will give us time to hear about this prior to the actual work being done.
All right, got a motion from Mr. Cohen, seconded by Ms. Capeen. All in favor of that motion, say aye.
Aye.
Opposed? Anything else, sir? Ms. Suarez.
They're looking whether or not I'm seconding everything. I just seconded it. It's fine. I was also out of the room when that happened, so I'm glad that you brought that up. So, because I was confused by the article in the newspaper as to whether or not whatever happened, because it was a lot of
The
words.
article in the newspaper seemed to be about a meeting other than the one that happened yesterday.
Yeah, I think it was a word salad that we couldn't figure out. So, well, anyway, tomorrow, Saturday, I think that most of my colleagues will be at the Equality Florida Gala. I will not be there with you. I am going to see Hamilton, and hopefully the words that were in the music that was from the Hall on Franklin is not included in the hip-hop version of Hamilton. So, yeah, exactly. Thank you all so much.
Okay, Mr. Shebda?
Yes, thank you, Mr. Chairman. I'd like to ask council to make a motion to direct me to amend council's rules of procedure, Rule 1B1, to change the date of election, the month of the election for a chair from April to May.
Second.
Mind to clarify to make it May 1st?
Actually, the way it would read would be that City Council shall elect a chair or chair pro tem at the first regular meeting on or after May 1st of each year. However, in an election year, City Council shall hold an organizational meeting for this purpose on May 1st at a special call meeting immediately following certification of the election of City Council members and taking the oath of office. So it's the same rule, just in accordance with your new...
It still means on the inauguration day that they will have
Exactly.
the special call meeting.
Exactly.
Okay, I just want to make sure we get that right.
And then we have a meeting the next day, right?
You would, actually.
Yeah, you have a special call and then you have a regular meeting.
All right, got a motion from Mr. Miranda, who's seconded that?
Second, I'll second it, whoever else.
Ms. Suarez, all in favor of the motion, say aye.
Aye.
Opposed?
Second.
All right, got a motion to receive and file from Mr. Miranda, seconded by Mr. Maniscalco. All in favor, say aye. Aye. Opposed? We stand adjourned.
All right, that was short.